Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court. The fireworks are not done.
Alleging commentary on the case. Dati mihi Anglican for service Latinos. Oh, for Trump's sake.
Good morning. Good morning. Happy Friday Eve. Welcome to the Court of Public Opinion. I am the Recovery Addict. So good to join you again so soon. Oh my goodness. It seems like we were just here, and it also seems like I did not sleep. But maybe that's because the 4 hours that I got were not quite enough. It's going to be a crazy day. Oh my goodness! We've checked in with Jules at the courthouse. She is there. She beat the defense team to the courthouse, so she's there. She says Sally Smith is present. Sally Smith is present at the courthouse. So it could be first thing this morning or anytime today. I don't know when that's going to happen, but we're excited about that. Last night, oh my goodness! Last night there was a terrible event up in Maine. They had an active shooter situation that we tried to share some information on. I'll tell you, it was difficult to get the information, and we ended up ending that live stream about midnight 30ish, and officially today there's going to be a news conference about 10:30 a.m. Where I believe they're going to both share the official details about how many people were both killed and injured in that, as well as we're going to hear that this has changed from an active shooter to a manhunt. And there, so our thoughts and prayers go to everyone in Maine, those who were affected. I know we had people on the stream last night who were sharing personal experience from the area, as well as people who knew some of the victims as well. So our thoughts and prayers are with all of them today, and pray also for the all the law enforcement that are involved from all the different agencies that are trying to bring that to a quick resolution to restore some sense of peace and safety in that community. 3 communities now, 3 cities. I think they just added, I think it's called Bodine. Is that how it's pronounced? They just added Bodine to the shelter-in-place order. It just blows me away that they have 3 towns locked down saying don't leave your house, and they're still just saying we have just one person of interest. I think at this point they can probably call him a suspect.
With 4.99.
Couple of quick things before we get going. We'll sort of move on from that topic. I realize that's a hot topic. We're here to talk about court today. That's what we're going to be following, the Maya trial down in Florida. Ella B, welcome as an attorney, nonetheless. Welcome. So good to have you here. Oda Marie? Is it Oda Marie? I'm guessing on that one. Welcome to the gallery as well. Good to have you joining us. We just had a super sticker from Joy B. Thank you. Hype. We're here. I'm so excited to hear the testimony and the juror questions from today. My girl Angela says, yay, 6 months. Thank you so much. But first, before we go too far, we have to recognize one person, and that is Paula Mack. Let me get this set up the way we want it. Paula Mack, you were first in chat this morning, which is no small feat. I don't know if this is a first offense for you, but being first in chat is an offense. It does go on your permanent record. And as a punishment for being first in chat, we're going to award you or sentence you with internet ownership and the responsibility to maintain everything IP related worldwide. So go ahead and buckle up for that one. Thank you so much, Paul Mack. We love the first person in chat every day that just opens the doors for everyone and says, hey, come on in. It's going to be fun. Kim, the Justice Junkie, just gifted 20 memberships this morning. Kim, that is enormous. What a way to welcome some of the new viewers we have. We have so many great friends that we have met from many other channels, including Rob from Law of the Lumber. Just awesome community. They came and felt like they were the friends from the moment we met them. So thank you so much. If you're here from Rob's Law and Lumber Show, thank you. Quite gingery. Welcome to the gallery. Welcome as well. Kate says, all right, are you going to be able to cover the Maya trial and the BK hearing this afternoon? We're going to follow the updates. because we're also recording another trial, the Colorado trial in Adams County at the same time. So I've got like 7 things going on today. So if I'm a little bit discombobulated, that's going to be the word of the day. That's going to be it. So I'll need your help just to help me cover. I think what's going to happen with the BK hearing, we're going to follow the news and just share it in chat as it breaks. That's not something we'll be able to live stream at this point. Later on, if cameras are allowed through the trial, that's when I do hope to be at and share a live stream direct from the courthouse throughout the trial. So that's where we're going with that one. Kim Hope, welcome to the gallery. Thank you very much. Connie Munster, I've been gifted membership so generously since April and hope to do the same for others. Connie, thank you. Thank you so much. I'm choking up a little bit. It's just a wonderful morning. You guys are so generous. What a way to welcome people. Thank you so much. I heard a buffer sound in there. There is a new Sarah Boone letter. When it rains, it pours. Oh my goodness. Sometimes we're sort of scrambling, saying, "What is there a trial we can watch today? Is there anything that's happening?" And right now, there's just so much going on that we can't look at it all. There is a new Sarah Boone letter. I will say that the lawyer covered this and probably did the most fantastic job. It may be something we cover prior to Sarah Boone's case moving forward. But at this point, we're not going to cover that today. But yes, a new Sarah Boone letter is out.
Illegal mumbo jumbo talkie recovery dude.
Hang on, I've got seconds to get going. The court should be in session here in about 7 minutes. I know we have to sing happy birthday to someone. Is there anybody who has a birthday today? Because we've got to fit that in really quick. The lawyer covered it. Pete Tragos does a great job. I know that he's going to be all over that trial once it begins. We're also going to follow that a little bit. Okay, here's Mel B. It's my 34th birthday. Is there anyone else that we get to sing to with Mel? Congratulations, 34. That's awesome, Mel. Let's see, Amy H51. Okay, Mel B. I'm going to need a mod to put all the birthdays. Roxy. Okay, I need a mod to put all the birthdays in one chat for me so I don't mess this up, because I know I don't want to leave anybody out. I need to run this back where it goes. I spent all morning trying to reset up my system, because the manhunt we were following yesterday was so it required a very different setup than what I have. So I think I plugged in all the cables to where they go, and we're hopefully going to get. Let me move this one as well. Hopefully going to get everything working just flawlessly from the get-go. And I think we're good. All right. So as far as birthdays go, I missed the Jane Mack. Love your work. Thank you very much for the super chat. Thanks for being here. Is that Australia? Are you watching from Australia where it's nighttime? Let's see, Mel B and Sherry and Amy. Was there one more? Mel B, Sherry and Amy. Sherry, congratulations. Oh my goodness. Okay. Do we have altogether one birthday list? Can somebody give that to me so I make sure we fit everybody in the song? We just have a couple minutes before the judge arrives, and he does not wait for any birthday songs. So we have to put this in quickly. I will say that I'm anticipating I've got an emergency bottle of Mountain Dew that I'm anticipating needing today, just because of the lack of sleep. Not for the Sherry Smith
Susan
part.
Steele
I'll be
just
awake for
sent
that.
a super sticker with
Susan
14.
Steele, thank you very much. Lynn Tate. Oh, okay. I don't know if I can fit everyone's name in here. Do we have any mods that can put all this together for me? I can't track all the birthdays. Okay, so Red Pen says Roxy, Mel B, Amy, and Sherry. Is there anyone I'm missing on that list? If I am, just know that it's not intentional. I wish I could sing to all of you. I think we can fit all of you in there. Everybody warm up with me. La 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 la. Okay, that'll work. Everybody singing positions, best voices, back straight, deep breath, eyes on me. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Roxy, Melby, Amy, and Sherry. Happy birthday to you. Beautiful harmonizing there in the back, 6-volt bus. I heard that all the way over here. That was fantastic. To everybody who has a birthday today, and to those who I missed, I think I missed a couple people. I hope today's fantastic. I know there are a million places you could spend your special day, including Denny's, where they give you free pancakes. But you choosing to be here with us is our honor. Thank you so much. I appreciate that. Hope you have a great day. If there's anything we can do to make your day just a little bit better, please let me know. All right. With that said, the judge said 8:45 this morning. I heard 8:30, Connie. I heard 8:30. That's the notes that I've got. And my birthday was Tuesday. Who was that? Jimmy Lawson. Happy birthday on Tuesday. I'm sorry we missed that one. But it's fun to spend the day together with you guys, and hope your day is fantastic. All right. With that being said, I think we've got all our audio systems set up. We're good on that one. And there. Got one feed going right now. Nothing from the courtroom as of yet. Jules was reporting. Let me see if I can just check in with her last text to me. Just one second. Let's see. She says, there we go. John Stewart that went to jail on the false child abuse of Sally Smith, and Jay Hatch is here. He has signs and is going to be protesting outside when she's done. I'll try to get footage. So there will be protesters outside when Sally Smith completes her testimony and is leaving the courthouse, which will be interesting. And Jules is going to try to be both in the courtroom and outside of the courtroom at the same time. And if anyone can do it, it would be Jules. So good. All right. I missed Dad's birthday. Dad's birthday tomorrow. We'll sing tomorrow, Andrew. We'll sing to Walter tomorrow, and a happy birthday. 80s amazing. That's something that deserves celebration. A lot of experience.
Yes, in Perth, Western Australia, thumbs up with medium light skin tone. Really enjoying your coverage. Good job.
Jane MC, thank you. Perth, Western Australia. I had a son who, I still have a son, who spent some time there in Australia, but it was down on the south end by Adelaide, and absolutely loved it. Just loves Australia. I've never visited, but that's something I'd like to do. But if I do, I have to take a metal detector, and if I find any scrap of gold, you'll never see me leave. I'll be looking there forever. You guys have the best gold nuggets in the world that are still being found. I guess there are a couple in California as well.
Thanks for the work always.
All right. Thank you for the kind words, Anna. This setup has taken years to build, and there are pieces that I purchased years and years ago, and it's and some that I raided from the family. This is the family's computer, by the way. I took it from them. They used it for homeschool. I said I need it. I'm sorry, so we had to replace that. I've got iPads from I think first generation iPads running here to try to keep the show going. It looks good on camera, but behind the scenes, with all the cables and the mess and everything else, it's basically just a fire hazard. But thanks for the kind words. Let's see. Salty Rules, welcome to the gallery. Thank you. It's wonderful to have you as a new member, as well as, let's see, your car's extended warranty. This is 4 months for you. Congratulations. Love that green courthouse by your name. Lynn, 2574 says,
Melanie ref Dr. Corcoran's testimony last night, compared to Dr. Anderson. Very interesting to see how all the evidence has fallen into place.
Melanie, speaking...
Man realize K great and green at Be Kind Tiger, at Polemic and at 80s Musk Man. Thanks for the generous PPL who gifted us.
Okay, so let me start here with Lynn. Melanie Little, attorney Melanie Little, who's also sent many of her viewers over this direction as well. So thank you very much, Melanie. I appreciate that. That's who we're talking about when they say Melanie reviewed Dr. Cochran's testimony last night compared to Dr. Anderson. Very interesting to see how the evidence has fallen into place. There is so much evidence and so much that doesn't fit together. Like we've got differing opinions from the same side. So Sharon McDonald says, wow, where has the time gone? Enjoying every minute of it here with the best family on the internet. 9 months, Sharon. Thank you so much. One of our fantastic mods. Love the work you do. Thank you. Kim R says, we look great in green. Be Kind Tiger, Paula Mack, and 80s Music Man. 80s Music Man? Did I miss that? Did this fantastic gift by Kim the Justice Junkie finally reach 80s Music Man, who has, for some reason, been on the naughty list from YouTube? That is wonderful. Let me see. That's wonderful. We've been trying to get a gifted membership to him for quite some time. That's wonderful. Thank you for making that possible. All right. Nothing from court yet. We're monitoring. There's no feed available yet, so we'll let you know. Maybe I was completely wrong on the time. We had an extra 15 minutes, and I could have sung to everybody individually. Opals, sapphires, and pink diamonds are the best down here in Australia. Australia has amazing geography, or what's that called? I was going to say geography, but what's when you study the rocks? The words escaped me right now. Geology, that's it. And the fact that people find like 44 pounds gold nuggets just out in the bush is crazy. It's crazy. It was, in fact, Krista who assisted the 80s. Krista, thank you very much. You made that possible. 80s Music Man, it's so good to have you back in green again. And know that YouTube does not have a personal vendetta against you. Krista, thank you very much. Amy H51, thank you so much. Have a happy birthday, Amy. Hope it's wonderful. Thank you so much for being here. It wouldn't be the same without you.
Thank you so much, Party Popper, Party Face with a party horn.
Hat and confetti.
Confetti ball.
Thank you very much. Oh, confetti ball. I haven't heard that one in a while. All right. Courtney Meek says, lurking in the shadows, about to walk into the office. AirPods, activate. When I was allowed, I used to work with the federal government, and there was a time before they made the area we were in. The term is open storage, which allows top secret material to be more open. But before they did that, there was a time when we were allowed to have phones and things in there. And with your AirPods, the trick was to have one in your ear while you're charging the other, so you could rotate back and forth throughout the day and always be able to listen. And then they made it open storage, and then all the cell phones had to be locked well outside the room. Gingy Probs, welcome to the jury. Thank you so much. Make sure you take a seat by clicking ! Seat or typing that in chat. We have reserved seats, and jury members get padded seats, I might add. Virtual, of course. Be Kind Tiger says, been here so much longer. So many new friends. Ari, thanks for bringing us all together. Be Kind Tiger, thank you very much. I do love the new name, by the way. It's very fitting, and I appreciate that. Thanks for the 7 months and more that you've been with us. All right, what happened late yesterday afternoon? Sally Smith issue. It may not be an issue at all, but there was. We have a subscriber, a viewer that works in the medical field that participated in a conference. I think it was an AAP conference, and at that conference there were topics brought up, including Munchausen by proxy, how to testify in front of a jury, and the viewer that reached out to us said that Sally Smith had participated in this conference as a participant, not as a speaker, and that this discussion was going on. This trial was brought up. In talking with Rob and the legal minds, probably the only way that would become a problem is if she had admitted to watching the trial. That would be a huge no-no. But other than that, it's probably okay. So it's probably not anything. But we did just raise that and pass some information along in case that was an issue. Let's see. I think. Let's see. I'm sorry. There's a lot of people in chat, and it's going fast this morning. JSF 1993. Let me see if I can see your comment. I can't enable gifted gifts. Any country restrictions on this one, or which ones? I have not put any restrictions in. I'm not aware of any country restrictions on my channel. We have people from all over the world: South Africa, New Zealand, Australia, Sweden, Ireland, Canada, Mexico. I think that's most of, we have people from all over, so there shouldn't be any restrictions, at least that I can control. It may be an issue with your account. If you have a branded account, a brand account, those can sometimes be a little bit of trouble to work with. But just make sure, I don't know, you might try a different browser as well. Sometimes it doesn't play very nicely with your gift settings on a browser. Okay. Man, if I knew that it wasn't going to start till 9:45. I know the jury was going to be here at 9, but I thought it was going to be 8:30 today. So, all right. As far as notes for today, the big thing is Sally Smith, and Jules says Sally Smith is there in the courthouse, and expected to testify. So that's going to be huge. Whether she's first or not, I'm not sure. Looking at the stop clock, or the shot clock for the two sides, we ended yesterday. The plaintiffs team, so Maya's legal team, has 54 hours on the clock, meaning that they've used 54 hours. They only have 59 total. That gives them 5 hours even remaining. They've been using about an hour 20 to an hour 40 a day for the past week or so. So if they continue to use about that same time, about that much time every day, they're going to run out quickly, probably mid next week, probably right a day or so before the defense rests. That's just some rough math. On the defense side, the defense has used 33 hours, so they have 26 hours left. And so that's still that's a lot of time because they've been using on average 2 to 3 hours a day. And so I don't know where they're going to fit all the hours in if they say they're going to rest next week. Possibly late Tuesday, possibly early Monday. Also, on Monday, we are expecting that we're going to hear from Kathy Beatty as well. She's been, at least dangled out there as a possibility. So it's going to be some spicy testimony here. Gingy Probs, welcome to the jury. Thank you very much. Also, Michael, welcome to the gallery. Good to have you here as a new member. Oh, not new member. You've got a green courthouse by your name, so a returning member. Appreciate that. Some people are saying, anyone want to bet she doesn't appear today? Sally Smith is in the courthouse. I believe she is on subpoena. So if she does not appear, if she gets called, she needs to appear. Okay, that's she doesn't have a choice in this one. They can compel her to appear. Did they catch that guy yesterday? No, they did not. Debbie, there's going to be you're talking about the Maine active shooter issue up in Lewiston, Maine. They did not catch him yet. It's switched to a manhunt. It's spread out a little bit. A lot more resources are being brought in, and we'll hear more at 10:30 when there's a press conference. Obviously, we'll be here in trial at that point, so we won't be able to cut to it directly. So probably some of you will be able to dovetail and share some information in chat as we hear about that update. Let's see. Dr. G's position on body language. Dr. G's video about Sharon, or Sally Smith, and sorry, I read Sharon from chat and I just inserted that. And Kathy Beatty, his video about them dropped yesterday. If you haven't watched that, he was awesome to come on the channel a couple days ago and preface that with us. And then he was in chat with us last night during the police activity up there in Maine. So I highly recommend you go to Dr. G's channel. You can type !doctor in chat, and that should, if it's working correctly, which I'm not sure if it is. If it's working correctly, it should post it on the screen with a link to his channel. All right. And then aren't the witness rules allowed to... Okay, aren't the rules witness are not allowed to be anywhere near this case being talked about? Marmite, the rule is... they invoke the rule. Okay, it's so common that invoking the rule, it has its own, it's just the rule. And that is the sequestration rule, where witnesses who are not experts, designated experts who are paid to analyze other people's testimony and all the facts, witnesses who are not experts, or the plaintiff, or direct family members, things like that, they are not allowed to watch any of the testimony from any other witness in the trial. This case is a little bit different because you've got Johns Hopkins Hospital, All Children's Hospital, who is being sued. And Johns Hopkins All Children's Hospital is not a person. So they're allowed to send a representative. And the defense has asked and received permission by agreement from the plaintiff's party to have rotating doctors who act as representatives for specific days for Johns Hopkins All Children's Hospital. And sometimes that doctor who might be sitting with the defense is one of the witnesses that we see or have seen in court before. So it's a little confusing. Normally they would not be allowed in, but on the day that they are the acting representative from the hospital, they'll sit there on the defense table. So that's why we see that. As far as all the other witnesses, like Dr. Kirkpatrick, who is not a designated expert for this trial, all the other witnesses that are all the other people, they're just the lay witnesses, they are not allowed to view the trial at all. So Sally Smith would not be allowed to watch any of the footage and coverage, and if it came out that she was, that would be a big problem, and the judge would have to address that. But great question there. Let's see. Lacey Ann gifted a membership. Thank you so much, Lacey. Appreciate that. New member yourself and gifting memberships as well. Carrie T, welcome to the gallery. Great to have you here with us. Thank you. Please file in. We just got the video feed from court, so we're going to pull that up. That's what we have right now. Let me see if we can get a secondary feed going as well. Okay. Margaret, this there's a lot of conflicting information going out, even right now, even through news channels like big news channels. The death toll from the incident up in Maine, the numbers are all over the place. Some say 16, some say 22. Even this morning, whether or not somebody was arrested or whether or not he was captured is also back and forth. The problem is the press conference they gave late last night, where they would normally provide some information, 4 hours, 4 plus, maybe 4.5 hours into the event, was almost nothing. They gave almost no information. So really, we just have people trying to gather what information they can on the ground and passing that on, and we're still waiting for confirmation on just about everything. Okay. We have not done a poll as to who we think are winning. The jury members obviously are supposed to be keeping an open mind through all the presentation of evidence, well, both the plaintiff and the defense. And we hope that is the case, although some of the questions are indicating that they might be leaning one direction or another. That is really loud. We'll get that fixed. I'll bring up the ejection counter here in just a moment. Audio's working. Objection counter right now is sitting at 1,401, which is a lot. My guess, I think, was 1,600, so I might be close. It was just a guess, so if I do nail it for any reason, it's purely accidental. I don't have any I don't have any magic 8-ball that's giving me the information. All right, there's our objection counter. I'll bring that up in just a second. I wanted to, before we go to, just 1 second. I need a different feed there. 2 is 2. Okay, before we go too far, I wanted to share a picture with you. Every morning, I take a picture of 3 trees, and this is my Zen moment when I get to just focus on what's beautiful in the world, and this is how I focus. So I'm going to share a picture just briefly. This was this morning. This is the 3 trees. I shared the picture the day before. Yesterday was very similar, and it looked like this. And the day before that, or a previous day, looks like this. So I share these pictures on an Instagram page.
Still looking for him. We are mostly shut down. I will update chat when I can if I hear anything of note.
Aurora W., thank you very much for the update. I appreciate that. We are obviously our thoughts are with everyone up there who's dealing with that, and hope that they have a quick resolution, and then all the peace and comfort we can pray for the families, those that are affected. Thank you, Aurora W. Anyway, the pictures after we had that crazy night, taking a picture like that of these 3 trees, which is something I've done. I've taken a picture every day of those trees for more than a year. I took a break, and now I'm starting to do it again. But I have an Instagram account if you want to see all the different pictures. Sometimes in a storm, sometimes with the sunrise peeking through a hole in one of the dead trees. But the Instagram account is these_3_trees, all spelled out with words. And it has, I think, like 6 followers. But if you want a Zen moment, I'll try to start updating that a little bit more regularly every morning with a picture of 3 trees. All right. That being said, it's just one of my side quirks. And one day I hope to metal detect that property. I currently don't have permission. It's an old farm property, a couple miles from where I am. I drive by it usually about the same time the sun's coming up. All right. Let's see. I think Recovery Addict missed my question as he's juggling so much. But does anyone know? Excuse me. Does anyone know how much time each side has left? Valerie, yes. The shot clock it's winding down for the plaintiff. They have 5 hours left starting this morning, and the defense has 26 hours left as of this morning. So that's where we're at on that one. Have you asked permission? Can't look if you don't ask. Yes, the problem is the property is owned by a trust, where there's a lot of different players involved, and no one wants to say, yeah, I'll let you do that. Even though usually when I metal detect somebody's property, what it involves is me going through and walking through. So I leave footprints, and I end up taking usually several pounds of just garbage, scrap metal, aluminum, little bits of, tractors, the plow bits that broke off, and bolts, and occasionally a couple coins, copper wheat pennies or something like that. But occasionally we find something really cool, like a $5 gold coin, which was really neat to find. That one actually I left with the property owner, and we were able to return it to the individual who lost it 75 years previously. We knew that it had been lost on the property, and I was able to find it for him. That was a fun story. Looks like the judge is coming in, so it's story time is over. Court is starting.
Okay, good morning. Please be seated.
My ears. That was terrible, you guys. I said I'd fix it, and I didn't. I will do that now. Okay. The loud noises will not happen anymore.
Computer's going.
I'm going to log in now as the judge is starting up the Zoom feed.
This is case number 2018 CA 5321. Jack Kowalski, etc. et al. Versus Johns Hopkins All Children's Hospital. Starting with the plaintiffs. Let's take appearances, please.
Greg Anderson, Nick Whitney, and Samantha Lawrence on behalf of the plaintiffs.
Howard Hunter, Ethan Shapiro, Pat Crowells, David Hughes, and Chris Altenburn on behalf of Johns Hopkins All Children's Hospital. And our corporate representative today is Dr. Richard Elliott.
Dr. Elliott's been here several days.
I see Mr. Altenburn's here in the courtroom. I did receive the further edits to the instruction. I know I think there were 3 changes. On page 2, I'm still not enamored with the proposed sentence disagreements concerning her treatment could be addressed by the dependency court. So my thought is we just don't say that right this second, and we'll continue to have discussions for the final version.
So when do you plan to read the final version?
Well, my understanding is that you all wanted me to read this today, and then we were going to have a written version that would go to the jurors with the collection of jury instructions.
Okay, because especially in the written one, I'm concerned with it ending in to participate in decisions concerning your treatment, because I think it needs more.
And I think we need to come up with some language that I can live with, you can live with, and the plaintiffs can live with. And I just don't think we're there on that one sentence yet.
Okay. And I had suggested a minor change to a sentence on page...
On page 4?
4 it is. I'm sorry, the blue highlighting, at least when it prints out, is darker than
my view on that, instead of using the word direct, let's use provide. So it would say the dependency court did not provide that Johns Hopkins could supervise the calls.
Okay.
I think we're threading the needle the best with that word.
Okay.
Your Honor, last night, for the first time, I had an opportunity to review the proposed order, and I took a stab at revising our version of it. You should have it right around now. I know you're invested in this one. I did not get a chance because I'm falling asleep with the computer on my chest trying to get ready for the next day. So I finally got 99% of it done. You should have it, all counsel should have it within the next 5 minutes. And I would really like to take a stab at helping, because I read through this, and just from trial counsel's point of view, I think it is going to raise so many questions with the jurors at this point that it's going to add days to this trial. And I honestly believe that. I want this to be as efficient as I can. I want both sides to have a fair shake at how to handle these orders. But I think there's a way to cut out a tremendous part of this. And my theory is this, that now that we have the history to compare to the orders, there's a bunch of terms, conditions, and in fact orders, such as the birthday order, which really have no bearing. There's no continuous time frame or alteration of time frame that would affect the jury's deliberation. So I tried to do was, and I know nobody's seen it, and I apologize, I just ran out of sleep time, I don't know. But my thought is if we can trim it down to the essence of those points that describe what they need to know as opposed to all of the orders, I think it would be more beneficial. And so that's what mine attempted to do. And again, I wish I could have gotten to it sooner, but I just got to prepare for trial too. So perhaps over lunch the court would have an opportunity to go through our proposed order. It's not brand new. It dovetails off of...
Well, let me ask you this. Are you just cutting things out, or are you altering language?
Both. But I think at least opposing counsel has seen the version that I was working off the one that you, Mr. Altenberg and Mr. Elliott were working on. So I think there is, again, quite a bit of it that is the same. In terms of the direct, when the court did the direct quotes of the orders, that's left in. It is simply cutting out some.
I'm not even sure he's looking at
the old order. I just don't know how to respond.
Versions at this point, honestly, because we don't have direct quotes in the version where we're at.
Yes.
Yeah, I don't think he's dealing with...
My position is that we've wanted to give this to the jury sooner, and admittedly it's complicated, it's taking time, but the longer we wait, the more confused the jury remains on me.
Well, I completely disagree. I think that this is...
Let's do this. You say you have sent it or are sending it momentarily?
Momentarily, yeah. Ms. Stump is she sending it right now?
She sent it, yes.
All right, you should have it. The court should have it. Counsel should all have it. And I have a printed copy.
Mr. Altenberg, were you going to be here today, or were you just coming this morning for this issue?
I was planning to make a cameo and go back and work on jury instructions, but I can stay a little while longer at least. But I will tell you on the jury instructions, I think we should have a packet to you, hopefully by, I'm not sure how soon you want it, but by sometime early this afternoon. The biggest concerns in that packet, at least from my perspective, are on the count 14 stuff. We're getting close to when we're supposed to rest, and I still don't know what the issues are, whether it's going to be a standalone negligence claim or whether it's going to be fitted in to med mal. Right now, what they're sending me is a standalone simple negligence claim that our training caused damages without any reference to a doctor being negligent in the interim. So there's problems with that one that I really need to understand before we can rest.
And do we have a verdict form draft coming with it?
We're in the midst of that, but I think we can make great progress on that today.
I mean, I would like, and I know you and Mr. Elliott are working hard on making it happen. I don't want to give you a deadline,
right?
But
I mean, I think we can give you something that's a working document by tomorrow. I do.
I'm going to explain this part. It seems funny that we're talking about
some of the jury
instructions and verdict forms in the middle of the trial, but I'll explain that in just a second.
I understand the format he wants, and I think we can probably work together on that today quite a bit. I understand that he has a law school reunion this weekend in Boston, and he's not going to be available for much this weekend, I guess. So.
Well, the sooner that you can get it to me, the better. That's the best. I don't want to put a time limit on it because I don't want to impact what you and Mr. Elliott.
And could I suggest that it'd be faster and easier if I can get you kind of the questions they're going to answer yes and no, and the elements on damages without worrying too much about the formatting of it, because the formatting of a verdict form is doubles time for me.
I'm probably going to end up doing the formatting myself.
Well, and that's actually what I told Mr. Elliott.
So I'm not worried about your formatting so long as it is in logical.
Again, I think by tomorrow morning we can give you the logics of this and the language pretty close to what you need to work with. So, and I will make that as my goal. If I say late this evening, trying to do it. So
Ms. Syback just brought in, I guess, Mr. Anderson, so I can hand you this, and Ms. Syback can print me another copy and bring that in. If you want to make a cameo again right after lunch
on this and the other thing?
On that issue,
I'm happy to do so.
And that way I don't hold you here. But
and I can give you progress on what we're doing on the other things by that point.
Okay.
Bob Reddy.
But on let's close the loop on this. I really want this issue to be put to bed coming out of lunch. So
should I get with counsel first and then talk to the court?
Well, he's got your work product, so can he take your work product and then, if necessary, talk to Mr. Elliott this morning?
Absolutely. Absolutely, that was the intent.
But I don't know.
This isn't a red line. This is just a set of changes.
There's a red line version emailed to you.
Okay.
So there's Jules in court. You can see her there,
confident
the glasses,
Mr. Altenberg, Mr. Elliott, or
the bling shirt.
Trial counsel getting in on their instructions. Anyway.
Well,
I'm told the copy that was served is not red line. I'm not sure I can tell on my phone.
The one email that we're looking at has no red lines on.
Did you get a red line version?
I'll make sure we get the red line version over.
Yeah. Okay.
Marianne, I don't have a graphic of that, but I can try to explain it a little bit
she
for you.
can print it and we can give it to you, Mr. Altenberg, and then you can take off.
If they serve it to me by the time I get back to my
great
alternate office, I can print it out there.
Altenburn office south?
Yes. And you want me back here at 1 o'clock, right?
That's a hotel room.
I'm happy to do that.
I don't know what time we're going to take lunch today because I don't have
at the end of lunch is when you want it.
Correct. So hopefully around 1-ish.
All right. Thanks a lot.
And I want to be clear where the defense is on Fabre. They've been stating that they were making a decision, that they made a decision on.
We have not.
I should have a decision by lunchtime.
Okay.
What's next? Judge, I have exhibit I need to put in before the witness this afternoon. It's a new exhibit it's not a new exhibit. It's an exhibit that the plaintiff has put in, but I've divided it into two packets because the defense position is that there are morning photos and there are afternoon photos. And so they merged them all together and mixed them up. And so I divided them up. So I would like to admit 3401.
Is this on this list?
It should be on the list. It is on the list. It's the last exhibit. I'm sorry. To put it in order, there's 3400. And I've given a hard copy of this to the plaintiff's counsel. 1 through 14.
We object, but I'll wait.
And 3401. 1 through 9.
Okay, and so just tell me what these are before we look at it.
Sure. Here's the deal, Judge. They put all these photos, they're already in evidence, all of these photos. They mixed them all together. You can tell by looking at them, in some of the photos she's in blue shorts, and some of the other photos she's in pink shorts. They merged them all together, they're all mixed up.
Is this the before and after court?
Correct, Your Honor. So I divided them up by before and after court, and I want to use them in that fashion with the witness because otherwise it's totally confusing for me to be able to use the exhibit. It's the same exhibit, simply divided into morning and afternoon.
So all of these exhibits are already in.
That's correct, Your Honor.
And it's just a reorganization and putting them. So what's the issue, Mr. Whitney?
Your Honor, first of all, they're already in. They can make the argument about blue shorts or pink shorts without putting this photographs into evidence twice. Secondly, what they've labeled as 3400, you'll notice, is not bait stamped. 3401 is. So the accusation that we mix these all up, we don't know the progeny of 3400 since there's no bait stamp on those.
Well, how about 3400-2? Are there any bait stamps?
There's no bait stamp on. I just looked at all of them. Anywhere in 3400, there are no bait stamps.
Judge,
and we must say, Judge, that our information.
Can we go back to just one lawyer per subject?
Yes, sir.
Thank you.
Judge, I don't recall if their exhibit has bait stamps. on them, but we can put the bait stamp on there if that's the issue.
Were the ones that came into evidence already, did they have bait stamps?
I don't recall, Your Honor. I don't know if they just had exhibit numbers, if they had bait stamps. Perhaps counsel can.
They did, Your Honor. Ours had bait stamps, and
can you give me just tell me the exhibit number that's in evidence and pull it up real quick?
it looks like 2604-006, 2604-001.
Let's just pull up the first one.
I'll just say these lawyers, it seems petty sometimes what they're saying, but they're doing their job. They have a very specific job to do.
2604-006.
They're doing it, and they're doing it very well.
2604-001.
Yeah, those are on.
And you'll see these have bait stamps.
Well, Judge, we can put the bait stamp back on if that's truly an issue. I mean, there's no question they're the same photos.
And all I'm seeing here are 3 photographs. I don't know if I'm sorry. Oh, they're not here in front of me. Okay. They all have bait stamps. We introduced them in the way they were produced to us. So the mixing up of order is not the blame doesn't go to us for that. This is the way the hospital produced them with bait stamps. We put them all in evidence. They can make their argument about blue shorts or pink shorts. There's a factual dispute about whether there were before and after photos. Of course, they take the position there were. Maya Kowalski says it happened one time. Kathy Beatty forced her in a dress in front of her and changed her before court. That's a factual issue that they can take up with the photos that are already in evidence.
We'll be happy to put the bait stamp numbers on. I think probably Dr. Lita, when we put the new exhibit number on, happy to put the same bait number now so they can do a comparative analysis. They're clearly the same photos. It would be... I think the defense has the right to have the jury see these as 2 separate packets, one before and one after, as opposed to getting them all mixed up when they're back there in the jury room.
The other point I need to make...
I'm sorry.
Oh, sorry,
Ms. Quarles, you can finish.
Sorry.
These are clearly, in our view, and the testimony will be, 2 separate photo sessions.
The other point I need to make is there's no date and timestamp to confirm that. So what's the point of putting them in this fashion? They're already in evidence. They can make their argument. If they were timestamped and dated differently, if one was a morning set and one was an afternoon set, from the face of them, perhaps. But that's not the case.
I think at this point, Ms. Quarles, if these photos are already in, let's just go with what's already in. I don't want to... If Mr. Whitney is correct that these were produced in a different fashion and not as a coherent set, I don't want to be seen as glossing a coherent set. If they're already in evidence, let's just go with them as in evidence.
Okay.
This can be frustrating, but a lot of the actual battles of court are lost and won here in this morning session.
As a matter of scheduling, the court had told the plaintiffs yesterday when we tried to publish emails whether we could just publish them or need to publish them through a witness since we're running out of trial days. The court asked the plaintiff to make a commitment this morning. So we would like to hear from the plaintiff whether they would require us to call a witness to publish or if we could just start publishing.
Anything further on?
I'm sorry, I wasn't paying attention. We were not allowed to do so, Judge. We had to put ours in context with a witness, with the court's ruling. We do not believe that it is appropriate nor particularly time efficient to stop the testimony to simply have the jury stare at a screen for a minute on each one of these. So we would object to just simply having them put in without a witness, any context or anything else.
Did I allow...
Did they allow it? I think they did. I think the plaintiff got to do it.
Plaintiffs to publish without a witness, and I'm not talking about a situation where we had a deposition and then published exhibits that occurred in the deposition, but did I allow plaintiffs to do this?
I did not during the course of what I was doing, unless Mr. Whitney remembers differently, during the course of what I was doing, we did not have that, and we actually asked for it within the first week to be able to put some of the documents into evidence before we had a witness up. We were not allowed to do that. The court wanted it to be in context with a witness if we're going to bring them in, and it's a waste of time here to just have the jury stare at these. I mean,
that's
at
a
least
weak
have
argument,
some
I think,
context.
a waste of time part.
The court did allow them to publish, for example, policies and procedures at the hospital without calling a witness. In terms of efficiency,
Was that in relationship to a deposition, or did I just?
I believe my sincere recollection is you just let them publish. In terms of efficiency, it's going to be far more efficient of the court's time for us to just publish, let them read, than for me to call a witness and walk them through. If they're going to require me to recall an expert, or require me to call somebody like Dr. Rich Elliott as a teammate.
Here's my thought.
Yeah.
I don't want to just force people to spend money to publish a document that's in evidence. I think at the bottom line that is wasteful of everyone's time, money, and energy. But I don't want to spend time publishing 30 emails. So, if you can do a handful and then perhaps get some others through a witness,
yep.
Obviously I will keep your time running during any publishing that you do, but I will allow you to do a couple of them without a witness.
Okay, so we will likely publish maybe 3 today. Okay, thank you, Aaron.
What's next?
This is chess. It's a high stakes chess game. So I think that was a big win for the defense. They can get some stuff in that might be difficult to bring in with a witness. Or
I guess now, unless the defendants have found something overnight, we still do not have the 2017 review of Kathy Beatty, which would be the one that encompasses the actions of the fall of 2016. And we need to know, once and for all on the record, whether that exists or not. And if it doesn't exist, then we may need to recall the defendant's expert on that point, because his opinions, the court may recall, included a review that apparently does not exist. So they found it?
I believe we did inform counsel last night, but I double-checked with my client's HR department, and the last review for that period ran through October 27, 2016, which is the one that they were handed, because they changed over systems. The next review did not start until July 1st, 2017, after the incident in question, 2018. There's no written review after 10/27, so there is none to provide for the second part. Yes.
So there's no review of employees by the hospital? I mean, that's what I'm hearing you say.
There's no written review of this employee between 10/27/16 and 7/1/17 when the next.
Are there written reviews of other employees?
I have to double check that, Your Honor.
Can I add, Judge, my understanding in speaking with the hospital is that they had a changeover in system. And because of that, there were no reviews done in October of 2017. They were done in October. In October of 2017, there isn't one. It's not until later that there's one. But I think the point, Judge, is the witness was testifying based on a document that ended in October of 2016. To the extent that the jury or the court or the other counsel is concerned that they were given the impression that there was a review he reviewed after that, we're willing to stipulate to a statement being read to the jury that says the review that was testified to by Mr.
Anderson.
Thank you. That's right, Anderson. Mr. Anderson was a review that ended in October of 2016. He did not review anything post October 2016.
Well, it seems hard to believe that an organization did not conduct reviews. How did the hospital make decisions on whether to give an employee a raise or not a raise? It would seem to me that an organization would not go more than a year without giving employees raises based on some sort of review. And I know of no organization that is of a large that doesn't keep written documents of performance. But maybe small companies where the owner knows everybody But
I hear you, Judge. My understanding, but we're going to double check. My understanding from talking to the people back there that do this is that because of some big, huge change, the reviews were all postponed and there was no review done and written performance evaluation.
For anyone?
Such as what was done before in October of 2017. But let us get clarity on that issue.
When was the next written review? And I'm not just talking about Miss Beatty, I'm talking about for everybody at the hospital.
Well, we only focused on Miss Beatty, so let us...
Judge wants to know for everything.
Re-ask with that broader question in mind.
And the question of how did they give raise determinations if you don't have reviews? I mean...
Let us clarify that, please.
Who's going to speak on this?
Yes, motion to strike the testimony of Mark Anderson to the extent that it involves opinions that where he based it in part on the 2017 review and/or a jury instruction to that extent in the event that there's not a satisfactory explanation for what that is.
I want to get more information before we decide what we're going to do.
Yes, sir.
And we will do that, Judge.
So all this has to do with the Mark Anderson testimony from yesterday.
An HR person come and talk about this, and that might have to be done on short notice, so get somebody on warm standby.
We understand.
Anything else before we bring in the jury?
The only thing I want to say on that, Your Honor, is in regards to the record, we had given defense counsel notice last night that we wanted to recall witness Mr. Anderson however this comes out. So we'd just like for that proposition to carry over until we get clarity. I don't know if he's flying out of this state. I don't know what he's doing, but we want to reserve the right to recall him depending on where this goes.
I think we've already said that he has to remain subject to being recalled.
Yes, sir.
Okay, so this morning we talked about the jury instructions and the verdict forms.
Your Honor,
if you need to sit down, want to stay seated, that's fine too, Mr. Hunter.
that's okay. That's probably better for me to stay down.
Is he not doing well?
I have two problems. The next witness is going to be Sally Smith. Number one, I have not spoken to her at all. We may need to have a discussion regarding what she should and should not say in view of Your Honor's admonitions the other day, which I intend to abide by, but I want to make sure she understands. But on the other hand, I don't wish to have her cross-examined about talking to me when all I'm doing is instructing her about the court's parameters of the court's ruling.
Well, why don't Mr. Anderson and Mr. Hunter go talk to her jointly? That
there's
way,
an idea.
There's not going to be any misunderstanding.
That's fine, and we can, but that brings us to problem two.
Problem two.
In the interest of judicial economy, I can publish a couple of emails. So, I'm sorry.
What's problem two?
Good. Problem two will facilitate what you... I don't know how else to put this, Judge. Siri took her to City Hall instead of here.
I'm sorry?
She went to the wrong place. Siri took her to City Hall instead of here.
She went to the North County Courthouse, or actually...
No, down the street, but she's about 10 or 15 minutes out. That's what I was...
Because sometimes when people put in Google Maps, they take them to a Waffle House off of... You think it's funny. The problem is that happens all the time. To a Waffle House.
Okay, so Siri, if you had Siri on your bingo card and Waffle House, congratulations.
Could be an advantage.
Well, City Hall is just 15 minutes from here. It's not too far.
That's what she said, Judge. But I mean, the traffic apparently was very bad this morning to start with, and this didn't help matters. Anyway, we could, I think what I'm hearing from co-counsel here is that if you want to bring the jury in, we can publish a couple of things, and she ought to be here by then, and we can step out and talk to her.
Is there a deposition we can play?
We're clipping a couple now.
We're close to Hannah being done. I am not trying a third attempt at Malik until plaintiff's counsel has reviewed the clip report. Did you cross?
I did, and I indicated one or two areas that you might want to look at.
Okay, but it needs to be clipped yet, Judge. I didn't want to have it clipped until plaintiff's counsel had reviewed it and agreed as to what was coming out. So it needs to be fixed, so it's not ready.
So no depositions ready to go.
How long would it take to clip it?
Well, I can't answer that question. But more than 5 minutes. I think there's a lot that has to come out.
Well, before I lose you, Ms. Crowells.
Okay, I was wrong. Hang on. I was wrong.
Johnson. I
read the message wrong.
On the plaintiff's objection.
It does say Sally Smith and Jay Hatch is here, but that was in another sentence. I completely own this mistake. This was not Jules.
I don't know if I missed it or if none are coming or you just haven't had a chance to do it.
I will check on that, Judge, with the team. I also believe that we're ready to send you Dr. Rose. I believe the plaintiff has done their counters and objections. We just need to get you the dep and everything.
Well, if Dr. Sally Smith isn't going to be here for a few minutes, you can publish, but maybe after a few minutes of publishing, we'll have Dr. Malik's deposition ready to go, and then we can play that.
We're trying to be.
Sorry, Judge. I'm sorry about the delay.
I apologize for Jules. I apologize for putting words in your mouth you did not say.
I understand it that Chapter 39
speed read your text.
efforts of Dr. Smith are going to be off limits for this. So it will be solely as to her actions at the hospital insofar as the issue over agency, and I guess that correlates in with any involvement on treatment teams or suggestions of treatment.
Here is the reality. The jury knows that Sally Smith has a role in the dependency court proceeding. And the jury knows that there was an ongoing dependency action. I am fine with, orienting questions as to her role in the dependency. What I don't want to get into is an examination of her 45-page report to come to the conclusion or her recommendation to the dependency court that Beata Kowalski had Munchausen syndrome by proxy. So a few questions to orient the jury about who she is and her background, that's fine.
No objection to that. Mine would be, to put a finer point on it, an instance would be the question over her conversations with Dr. Kirkpatrick, which could go either way. In one way, if she's an agent for the hospital and she had conversations with Dr. Kirkpatrick, and there's evidence in the record from Dr. Kirkpatrick and his memo at the time that he did.
I think I cut most, but not all of that conversation from the deposition designations last night. I think I left in one or two, but cut, I think, the majority of them, if I remember correctly.
Okay, this is for which depot?
Hannah. Oh, you said Kirkpatrick. I apologize. Because there were questions in Dr. Hannah's deposition about discussions with Dr. Sally Smith.
Yes.
I cut a good number of those out, but I left in a few, which those original questions and calls, it does not offend me, and I don't think it gets into Chapter 39, if there's just, hey, did you talk to some of these doctors?
Right. That is exactly what we wanted to ask, because it puts her on notice, obviously, to the extent that she is involved in the care of Maya Kowalski, that she knows she has these other doctors as a resource. Dr. Wassenauer, and then there's Dr. Hannah, and there's Dr. Kirkpatrick. And so I just simply want to ask her, did you have these discussions with them? Were you aware of this as of X time? And that's all I really need to do.
Lisa, that's dedication.
I did not intend to go that far. I'll make a proffer when it's all over with, but I read, I got a transcript of what Your Honor told me the day before yesterday, and I've in figuring out how I'm going to try to do this, I've tried very much to abide by it.
And I appreciate that. The fact that Dr. Smith has talked to a few or a bunch of doctors, that does not, I don't think that's problematic. It's once you start getting into the substance and the prosecution of the dependency court action, that cannot be discussed. So,
I will not.
Did she have discussions? Yes, but once we get into the substance of those discussions, I think that's where we need to draw the line. Does that
I think so, Judge. I mean,
work with you?
We're going to inevitably touch on the fact that she was, as Your Honor pointed out, conducting an investigation, and she's doing this. But our entire point is that we're not talking about that. That's separate track, if you will. So I've tried to design this thing in such a way as to avoid that, and I don't know where the cross is going to go. That's not my thing. But what I've tried to do is focus on her role and lack thereof at the hospital, and her lack thereof with the treatment team, and the fact that what she did, she was doing as a CPT captain. That's the whole point of it.
Yeah, and I understand, and if you need to approach, I'm going to let you have approaching, and we can, if there's a specific question, we can deal with it. It's like in a car crash case, when a investigating officer is doing a car crash case and they switch it over to a DUI investigation, they change hats, and there's a very clear demarcation. We just don't have that in this particular case, and we'll just have to address it.
I think from what I heard, Your Honor, I think I'm okay with if we just proceed. But there will be, on my end at least, there will be like passing reference to what she was doing, but I'm going to be talking about what her role was, not what she was doing.
Perfect. Okay. So let's do a couple of publishing of depositions. If Dr. Smith isn't here and Dr. Malik's deposition is ready, we'll do that. If Dr. Smith is here and Mr. Anderson and Mr. Hunter have spoken to her, then we can call Dr. Smith then.
Okay. I'm not sure we need to talk to her based on what Your Honor just said.
I suspect it's better if the two of you jointly discuss with her what we just talked about.
Very well.
I can publish 3 emails at 4 or 5 minutes apiece. That'll take 15 minutes, and then hopefully Mr. Anderson and Mr. Hunter will be ready.
And if Dr. Sally Smith isn't ready, then hopefully by then the deposition.
Okay, so we're going to have some silent show and tell coming up, which is judges authorized.
We need to talk to Sally Smith, and then we can take it the rest of it, Judge.
Bring in the jury.
Bring in the jury. Okay, here we go. So this morning, they're talking about the jury instructions. Jury instructions are the rules that this game is played by. These are the rules that the jury uses to reach conclusions. And it seems...
Smith is here.
Okay. Dr. Smith is here. There we go. Okay, so she's here. Jurors entering. Anyway, so those rules, they're important. They do fight over them a little bit. The defense has been primarily drafting those rules, and then the plaintiff sort of objects and modifies a little bit. That's a strategic move, as we've heard before from Rob. That Mr. Altenburn and Mr. Elgett are the appeals
Good morning.
attorneys.
Please be seated, everyone.
And so they're
I want to confirm that while you were away, you did
that.
not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. And has anyone approached you about this case? No. And have you seen any media accounts about this case since you were last with us? Okay. Mr. Shapiro.
Thank you, Your Honor. We would like to now publish what's been received into evidence as Defendant's Exhibit 3144, email of Beata Kowalski to Beata Kowalski regarding coma day 1, November 18th, 2015.
This is a big win for the defense because this just looks. It looks.
It should
bad.
be on your screen.
It looks rough, and they get to read it, and you're going to hear notes furiously being scribbled. Okay, so we've got the jury instructions, the verdict, and verdict form. Those are being. I think some of those are going to be read to the jury now, just to help them prepare for deliberation, even though they don't start deliberating now. And then they'll also have jury instructions, them read to them at the end of the trial. The defense is allowed to admit these documents without having a witness lay the foundation and verify the authenticity. They're basically by stipulation. So this is a big win for the defense. Had the plaintiff not also had this treatment previously in trial, this would not happen. This is not normal. Usually you have to submit it with a witness who can verify and vouch to it and authenticate, lay the foundation, and then you bring the evidence in. So big win for the defense as they get these in. These were fought over quite a bit as well. No, it's not a cardboard cutout of Sally Smith. We think she's here. The judge says she's here, and I believe them. These are just emails. The emails that they're showing right now are emails from Beata to Beata as rough drafts that we're going to be, or as final drafts that we're going to be published on the blog about Maya's treatment throughout this. And they're written in first person, even though they're written by Beata. They're written in Maya in first person form, which is interesting. It's not like a smoking gun. I think there might be something they could glean from this about getting medication or something like that at home that could help them a little bit. If they are. There goes Hunter and Mr. Anderson going to go meet with Sally Smith right now. And Mr. Whitney, it's all up to Miss Lawrence now. She's the only lawyer on the bench for the plaintiff. Hunter, Anderson, and Whitney leaving to speak with Sally Smith now. So on Zoom, yep, it's going on. We just saw it on the live feed right now. Thank you very much, Lauren, for catching that. Jennifer, I've got to do some heavy duty lifting to get this fixed, and I think I have to recode a program, which I'm not excited about. Comments show up really well because I have a black window behind them, but super chats for some reason don't. So I'm going to be reaching out to the creator of this. It's actually a Chrome plugin I use for putting these up on the screen, and see if we can get that fixed. I could have a black window always up at the bottom of the screen. I could make the main picture much smaller. There are some ways I can get around it, but I'd want to show you the best picture I can. Mr. Anderson comes back in and said, "Hey, we need a bailiff out here." I'm not sure why. Probably to open a room to go talking, to unlock a room that they can discuss things outside of the public view. Okay, let's see. Is there anything else I was going to talk about before we start? There's Jules right in the middle of your screen right now. Just looked up and back down. And there is Jack, looking spiffy as always with the tie bar. Love the tie. Snazzy suit. Pauline, we haven't had any extra time awarded to the parties since the judge gave them 4 hours each to go from 55 to 59 hours. So I'm not sure if there will be any more time added. Is Jules a reporter? Yes and no. She's what we call a citizen observer reporter. She's a true crime fanatic and incredibly detail oriented. Takes meticulous notes. So I would definitely put her in the classification of a reporter. Fun fact: there is no national test or body that grants membership in the reporter club. anyone can be a reporter. It's actually sort of written in the Constitution. So yes, I'd count her as a reporter, even though she does not work for a news organization directly. Jordan Timms, did some of the jurors cry during Maya's testimony?
Well, I'm just waiting for all the jurors to be finished before we go to the next one. Does anyone need more time? Okay, more time. I think they need more time. Okay.
See, this is strong evidence. This is
Mr. Shapiro, I think you can go to the next one.
The defense publishes what's in evidence as Defense Exhibit 3145, email from Beata Kowalski to Beata Kowalski, Comity to 11/19/50.
Need a screenshot, you can grab that there or rewind to this point. Megan, of course you can be a reporter. What we say to anyone who wants to go and observe in court is, number one, learn the rules of the court. Learn the decorum orders that have been filed, what is allowed and what is not. And please, please, please behave well within those guidelines. Court is not the place where you get to express your opinion as you choose. You are a guest there, and a guest that can be uninvited quite easily by the judge, and it could have ramifications on your freedom, depending on what you do. So definitely behave and follow all the rules. Be respectful, even in the manner in what you dress, how you appear, how you behave, and you can really have a great time in court. As far as courts are concerned, they do treat media, they treat what they call credentialed media differently than the public. So although I said everyone can be a reporter, the court may have a process to authenticate individuals that want to be considered media for the trial. Generally, those media members have additional restrictions put on them on what they can do, on the behaviors that go beyond what the public is allowed. Say, for instance, taking pictures, making recordings, use of electronic devices in the courtroom. They have additional restrictions and have to be aware of that and follow those as well. And so that's why they have these credentialed media. If you want to become that, every court, every trial has its own process for doing that, and you usually have to file motions and sometimes notices with both parties.
The defense publishes Defense Exhibit 3146, email Beata Kowalski to Beata Kowalski, 11/20/50.
One exception we found to that is in Bexar County, Texas. For example, Judge Stephanie Boyd's courtroom is open. Everyone is treated as a reporter. Everyone can bring a camera. Everyone can film. Everyone can take pictures. That is rare. That is rare in court. So if you want to go to court and you want to bring a device, you want to record something, you want to take pictures, first learn the restrictions that judge or that county or even that state has on behavior in court, and follow those to a T, unless you might end up losing things like your electronic device or access to court.
Thank you.
Sorry, I was going to let you get a screenshot. I was too slow. Megan, yeah, you're experienced enough. You'll know what's going on. You're fine. Just know that a lot of these trials that we follow have a lot of public interest, and even just getting into the courtroom sometimes involves basically reenacting Black Friday events at a big store for a sale, lining up well before the courthouse opens, sometimes entering a lottery system to be drawn a random number, as we saw in the Murdaugh trial. I think they had that. Dr. Patrice Berry, psychologist, responds, thank you very much for being here. Loved your input. I realize you've got work to do as well. Love when you can jump in and join us. Gamer Ducko, The judge seems to agree with you on this, that these emails are a nothing burger. He's basically said several times, he's said to the defense, what does it matter? Say you have a smoking gun and can prove that Beata had Munchausen by proxy, or that was occurring, and even that you could say, they could prove that Maya did not have CRPS. Say they prove all that. What does that have? What effect does that have on the charges of battery? Basically the illegal retaining her, separating her, not letting her leave when she wanted to leave. How does that affect these charges that the family, the plaintiff, is leveled against your client? I would say it doesn't. The judge says it doesn't, but they seem to be putting all their effort into proving this Munchausen by proxy, which would say that, if they can prove it, then they can say, well, some of our treatment of Maya, like our medical treatment of Maya, would be reasonable based on what we know, based on what was happening. Well, most of what the plaintiff is filed against in their allegation as pled against this defendant is that we're not objecting to, the nurses coming and checking on her and giving her chocolate cake or taking a chocolate cake probably. What we're objecting to is the pictures without permission, the treatment that violated the standard of care. That's what they need to focus on.
Mr. Hunter.
Very well, Your Honor. May it please the court. Our next witness is Dr. Sally Smith.
Here we go. She's been called. I don't know if the jury cried during Maya's testimony. I think they were touched by it. We'll have to ask Jules. I apologize, Jules, once again. I had said that your text said that she was in the courthouse already. I reread it, and I had jumped and skipped 2 words. It said Sally Smith and J. Hatch is here at the end of a sentence, and I read Sally Smith is here. And it was the end of a sentence saying John Stewart that went to jail on a false child abuse by Sally Smith and J. Hatch is here. So I abbreviated that into what I wanted it to be. I apologize for that. Okay, let's if we can, please keep chat focused on the topic. And keep it relevant. Let's not have a lot of chatter, as we've got a lot of people in chat right now. We're trying to pay attention and just put in important things here.
I do.
Come this way. And you're gonna have a seat in the witness stand there.
She brought 3 binders, 4 binders, 5 binders, one being purple, 6 binders. She's building a wall of binders.
Morning.
Good morning.
Tell us your name, please, ma'am.
Sally Marie Smith.
And what is your occupation?
I'm a pediatrician.
And where do you presently practice your profession?
I'm a partner in a pediatric general practice in St. Petersburg called Fifth Avenue Pediatrics.
And you have several other pediatricians that work with you in that practice?
Yes.
Okay. And that's basically a private practice of pediatrics?
It is.
Okay. Would you give the jury a brief, I think the jury's heard some of this, but if you give the jury a brief overview of your background and training in your profession, please.
Okay. My undergraduate degree was Bachelor of Science in Biology from Georgetown University in 1980. I went to St. Louis University School of Medicine and graduated in 1984. Pediatrics is a 3-year training, and so I did my first year and a half of my pediatric residency at what was then All Children's Hospital. And then I moved back to St. Louis and completed my residency at Cardinal Glennon Children's Hospital, which is the children's hospital affiliated with St. Louis University. And I did an additional year of training in what they call ambulatory pediatrics. I sort of had a career path trying to be a teaching general pediatrician. And so that was the focus of that additional year of training.
Okay. And did there come a point in your career at which you became interested in child abuse pediatrics?
Yes, actually, when I was in medical school.
Okay. Tell us how that came about and how you developed that specialty.
I believe I actually became interested first because of some children that were in the ICU when I was a resident who had bad injuries, and when I did my in medical school. I got ahead of myself. In medical school, I did a rotation with the county medical examiner who ran the morgue in the city of St. Louis. And because I was interested in pediatrics, she had me review all of the pediatric deaths from abuse that she'd seen over a period of maybe 10 years leading up to when I was there. And that got me very interested in the idea. And then, as a resident, I saw additional children that increased my interest. And then, in my fellowship in ambulatory pediatrics, I worked with the director of the sexual abuse evaluation program at Cardinal Glennon Children's Hospital. I worked with them like once a week or close to that, seeing children in their sexual abuse evaluation program.
Did you subsequently undergo additional training in child abuse pediatrics?
So, because of when I started this, which was in the late 80s, there wasn't really what's called fellowship training in child abuse pediatrics. So what I ended up learning over the years was mostly through experience. And beginning in 1988, I was the director of a sexual abuse evaluation program in New Brunswick, New Jersey at the Robert Wood Johnson University School of Medicine, and I was a teaching general pediatrician there. And then in 1990, I moved back to Florida, and I actually took a general pediatrics faculty position at All Children's Hospital. And as part of my job, I asked them if I could work with the child protection team. And so from there, I just ended up seeing virtually all the children that have come through All Children's Hospital for the last 32 years who needed evaluations for alleged child abuse and neglect. So I gained my training, if you will, in the trenches, just seeing children, looking things up, reading about it, checking with expert colleagues, learning from the radiologists, the neurosurgeons, the other people who work with these children down at All Children's, and ended up acquiring a pretty high level of expertise.
Did there come a point in time at which you applied for board certification in child abuse pediatrics?
Yes. So in 2009 was the first year that a board certification was made available for the specialty of child abuse pediatrics. And at that time, as I mentioned, because there wasn't really a fellowship in child abuse pediatrics, which would be 2 or 3 years additional training, the people who were allowed to sit for the exam could also be people who had at least 5 years experience in evaluating children for child abuse, were working in that specialty for at least 20 hours a week, which I qualified for both of those. And also you needed to have essentially a letter sent to the American Board of Pediatrics from someone who was kind of a recognized expert in child abuse, who would sort of vouch for you, that you were a person that should be allowed to take the exam. So I took that exam, I believe in November of 2009. It was in the fall. And then I think early January was notified that I had passed the exam and therefore was board certified in child abuse pediatrics.
Okay. Now, did there come a time in your career at which you became involved with the child protection team for Pinellas County?
Yes, so I worked for All Children's I'm going to keep leaving out the Johns Hopkins because I've just been using that term for 32 years. But anyway, when I went to All Children's to join the faculty, I started working with the Child Protection Team in Pinellas County, and the hospital basically had an arrangement where they billed the Child Protection Team when I saw cases for them for the hours that I worked, and allowed me to have the time to do that. And so for that 12-year period when I was working for the hospital, I was on campus, and so vast majority of the children who were hospitalized where there were allegations of child abuse and neglect and a medical evaluation was requested, I did those evaluations. So I was a consulting pediatrician for the Child Protection Team during those 12 years. In November of 2002, their medical director left, and they asked me if I would take over as the medical director. So at first I tried to work out a way to keep my job at All Children's and also do that, but it wasn't really very practical, and so I ended up resigning from All Children's at that time and became the medical director for the Child Protection Team. So for Pinellas County, that's about a 20-hour a week. I ended up working more like 26, I believe, over time, but it's about a 20-hour per week job. And so I did that, and within a few months, I started working at this private practice where I still am.
Okay. Let me back up a little bit there and try to clarify a couple of things. You indicated you resigned from what was then just All Children's Hospital,
right?
No Johns Hopkins,
right?
In 2002, is that right?
Correct.
And at that time, you became the director of the Child Protection Team for Pinellas County, correct?
Right. The term they use for the physician is the medical director. So I was the medical director.
So, what is a Child Protection Team, and who constitutes it? Who were you working for at that time?
So the Child Protection Teams, Florida has a kind of a model program for the country, and it was set up in the late 70s. I think that All Children's started.
Objection, Your Honor. This is beyond scope.
Sustained.
Move to strike.
Sorry?
Sustained.
Can we approach him?
Sure.
Mr. Hunter's like, you sustained what? A little confusion. Okay, so do keep in mind, yes, she sounds out of breath. She was carrying 3 years worth of binders, huge binders up with her. She's running. She went to the wrong place because Siri took her to the wrong place down at City Hall. So she's late for court, running to court, gets there, probably faced protesters outside as she came in that were probably not saying nice things to her. Running to the courtroom, gets there. The first thing the bailiff does, drags her in. She's talking to 2 attorneys, and then she's pulled into court. So we're definitely going to give her some space. She's out of breath. She's settling down. She's doing a good job. She's looking at the jury. She's answering questions well. I think she's becoming more comfortable as this progresses, and I think she's going to do already. I would say that the way she's presenting in this testimony is coming across better than how she did during her video deposition. So, sidebar can let her breathe for sure. I'm surprised by the amount of notes that she brought. And that was consistent with her deposition as well. She had all her notes, everything.
I'm just going to ask a different question, and the jury will just disregard that last question.
I want to fast forward a little bit, if we can, without a history lesson.
Okay, sure.
The CPT, well, let me back up. We've talked about that you resigned from Johns Hopkins from All Children's Hospital in 2002.
Right.
And have you ever worked for them or been employed by All Children since then?
No.
Have you ever been employed by Johns Hopkins All Children's Hospital?
No.
Or Johns Hopkins?
No.
Okay. Without going into the historical details, well, let me lay the predicate this way. When you saw Maya Kowalski in 2016. Were you the medical director of the Pinellas County Child Protection Team at that time?
Yes, I was.
Okay. And you had been so since 2002 in one role or another?
Correct.
And tell the jury, if you would, what a child protection team is.
Okay.
Objection again beyond scope.
No, she can answer that question.
So in Florida, each county is covered by a child protection team. It's a multidisciplinary team that includes a medical director, usually nurse practitioners or sometimes other physicians from the county who are supervised by that medical director, and social workers who serve as what are called case coordinators. So they communicate with all the people involved in a particular investigation or case. And they also have like a team psychologist, for example, that's contracted, a team attorney, I believe. So it's a multidisciplinary team with these members, and it provides, especially in Pinellas County, one of the biggest functions of the child protection team is to provide medical evaluations when there are allegations of child abuse and neglect. And there are certain criteria that are set up under statute in terms of which kinds of situations warrant a medical evaluation. And so we kind of follow that list, if you will, in responding to requests for evaluations. The vast majority of the time, the request is made by the Child Protective Investigation Division under the Department of Children and Families. The child protection teams are under the Department of Health in Florida, and so they work side by side, but DCF doesn't run the child protection teams, and so they request for us to help them in investigating their case by looking at the medical information and guiding them in terms of whether there's medical evidence that would support a diagnosis of child abuse and neglect, and whether a child's safety is at risk as a result of that.
Okay. So in any given situation of a child abuse investigation, what is the role of the child protection team and its medical director in pursuing that investigation or facilitating that investigation?
So primarily the role is to provide that medical evaluation, and it kind of varies exactly how much work is required to do that. But also we end up being a go-between with the dependency attorneys, the child protective investigators, the detectives or law enforcement that may be involved in a case, again, to provide that medical expertise to assist everybody in making a good decision for the child. We present information in court on a fairly regular basis and assist the dependency judge or the juries in evaluating the cases for whatever legal action may be needed. And one of my roles, which is also in statute, is to provide education for community medical providers.
It's going well beyond.
Overruled.
So in that role, particularly for a teaching hospital like Johns Hopkins Children's Hospital, it's the residents are required to have a certain amount of training in evaluating child abuse and neglect. And so over the years, I've been involved in that element as well to help provide education for the medical students and residents there at the hospital.
Okay. And do your statutory duties as medical director of the CPT, in your understanding, require that you consult with healthcare providers in a situation where a child has been sheltered?
There certainly are scenarios in which that's an important component of what were my responsibilities. Not always, but many times, especially in more complicated cases, the treating physicians at the hospital may need an ability to consult someone who is more expert in child abuse or neglect case for a variety of reasons.
Now, in the fall of 2016, and particularly in September and October of 2016, you told us that you were the medical director of the Pinellas County Child Protection Team at that time.
Correct.
What other hats did you wear as a pediatrician in the community at that time?
So I had my private practice. At that time I was working half-time there. Now I'm full-time. And I also, ever since I moved to Pinellas County in 1990, I had active medical staff privileges at All Children's Hospital. I do to this day. And that doesn't mean anything about being employed by the hospital or being somehow under the hospital, but the medical providers that go in the door there have to have credentialing in order to go in and see patients, communicate with the other physicians, review the medical records and the radiology studies and lab work and all those kinds of things. And so that was essentially another hat where I was active medical staff with the hospital. And then as a community pediatrician, and obviously I'd been there for 12 years, so I was well known to the medical staff members, and they asked me to be a representative on a number of hospital committees over the years as a representative of the community to sort of bring that to the table. So I think at the time in 2016, those were the main additional roles that I had besides being the medical director of the child protection team with regards to All Children's.
Okay. At that time, in the fall of 2016, did you have what we refer to as staff privileges, medical staff privileges at hospitals other than Johns Hopkins All Children's?
Yes, I believe the only one as of 2016 would have been Bayfront Medical Center, which is Orlando St. Pete now or something, where I've had privileges since 2002 to see newborns in the nursery there. I mean, I have staff privileges, but that's what I actually use them for.
Okay, so you would have privileges to practice both at Bayfront Medical Center and at Johns Hopkins All Children's Hospital.
Yes, and in addition to being able to walk in the door and evaluate children as the medical director of the child protection team, in 2016, I still had some patients from my practice that were complicated patients that sometimes I would admit to the hospital and manage their care. That was a different hat. That's my private practice side. That's all been taken over by the hospitalists in recent years, but I used to do that multiple times a year, admit my own patients to the hospital.
Okay. Now, in this particular case, how did it come about that you became involved with Maya Kowalski?
So the main way I became involved was because there was a report concerning child abuse or neglect.
The scope of that. Thank you for the report that. Unless I could.
Approach. Can't have a speaking objection there, especially when we're dancing along a very fine line. Mr. Anderson said objection unless I get to go into, and he's like, hey, if he gets to go there, I want something back as well. I think Mr. Anderson would prefer to get to go into what he wants if this is allowed in. Or I think he would, if he had the choice, he would allow both in. Mr. Anderson would allow both sides in instead of just the defense getting to bring this in. Or I said that wrong. If Mr. Anderson had an outcome that he would like, I think it would be that both are allowed to go into an area that is sort of on the line instead of the defense not being able to go into this area. There, I finally got it out. Third time's the charm. So Megan in chat saying, it's killing me. I can't go live till this afternoon. Can't wait to see some of the legal analysis of what's going on here today and some of the great channels out here in LawTube.
You may continue, Mr. Hunter.
Thank you, Your Honor. May it please the court. Let me focus this a little bit.
Okay.
In early October of 2016, did you receive a call regarding Maya Kowalski from Dr. Beatrice Tepa-Sanchez?
Yes, I did.
And at that time, when you received that call, did you have any knowledge of Maya Kowalski or her admission to All Children's Hospital?
No, that was the first I learned of it.
Okay. And Dr. Tepa-Sanchez contacted you regarding concerns that she had?
Yes.
And what did you do to tell us very specifically, and not at any length if you would, what you did in response to that phone call?
I talked to her on the phone about, she was asking me about what to do about a possible case of, I believe her terms were Munchausen syndrome by proxy. And we talked about the kinds of things that are needed to assess that diagnosis, such as medical records.
Objection as to
what?
Oh, you can continue, Mr.
Okay. Great. Sorry.
And we also talked briefly, as I recall, about this specific case. And I tried to give general advice in terms of how pediatricians can approach concerns for Munchausen syndrome by proxy, or what I prefer to call medical child abuse.
And were you called at that point as a member of the child protection team or as a medical staff member at Johns Hopkins All Children's Hospital, or do you know?
My understanding was I was being called as the person they all had known for 32 years to be the hospital expert in child abuse and neglect, as an active medical staff member, and another active medical staff member was seeking my assistance, advice about what to do about a case where there was concern.
Now, with a call such as that, would that be considered a consultation?
That would be my understanding of what that's what I thought it was.
Did you access the medical records from Maya Kowalski at that time?
I believe I did briefly, yes.
And did you take any further action as far as evaluating the patient herself and her medical care at that time?
No, because to do anything as a child protection team medical director, I need to be asked by the investigators to provide a medical evaluation. And at that time, to my understanding, there was no actual investigation ongoing yet. And Dr. Tepa-Sanchez wasn't the person under Florida law who can ask me to provide that medical evaluation. So it was a Saturday, as I recall, 1-ish in the afternoon, and we had a little discussion at that time, and then I honestly didn't think about it more, do anything more about it until Monday, when I got that referral where the child protection team was asked to provide a medical evaluation.
Okay. So between the time that you spoke with Dr. Tepa-Sanchez and looked at the chart briefly, and the time you were advised of an investigation on Monday morning.
As I recall, it was Monday morning, yes.
Did you take any action to render diagnosis, care, or treatment to Maya Kowalski?
None whatsoever.
And so you had a brief telephone conversation, and until you were told there was an investigation, you took no other action to involve yourself in this patient's care?
Correct.
Now, once you were advised of the investigation, did you undertake well, first of all, and I want you to answer this question very narrowly.
Okay.
Were you advised of an investigation and asked to conduct a medical evaluation as the medical director of the child protection team?
Yes.
And is that the point at which you began your investigation of the case?
That's the point at which I began my medical evaluation of the case. I wasn't the investigator. Those are other people. I was providing a medical evaluation for the child protection team to assist those other people.
Okay. And in conducting that investigation, were you acting as a medical staff member of All Children's Hospital, in other words, a pediatrician in consultation, or were you acting as the medical director of the child protection team?
You know, there's a slight overlap because the privileges that I have at the hospital allow me to review their records and enter the building and examine children and things like that. So there was a slight element of my active medical staff credentialing that was in play, but primarily I was acting as the medical director of the child protection team.
Who was conducting the care of Maya Kowalski at that point?
At that point, she was in the pediatric intensive care unit at All Children's, and so the ICU physicians, the pain management team, I'm not sure if there were any other consultants that were involved at that point. Certainly all the nursing staff and the support staff and everything were the ones that were managing her care. In not just this case, but in child abuse cases, I don't really get involved with the management, day-to-day management of the children at all. My role is specifically to do this medical evaluation. And so I focus on that part and not really anything related to, you know, whether the child gets a regular diet or what medications they're on or how often they're getting vital signs or any of that kind of thing.
And is your involvement in the medical evaluation as the CPT medical director part of in your understanding, part of your statutory duties as the medical director of the child protection team?
Yes.
With respect to Maya Kowalski, did you ever write a consultation in her chart?
So the physicians that are treating the children that I see down there for a child abuse evaluation obviously are going to be helped if they know all of the medical data related to that potential diagnosis. And so recently there's a different electronic medical record system and it doesn't exist anymore, but at the time that I was involved with this case, what I would routinely do would be to provide my medical report to the treating physicians at the hospital to assist them. And that's okay when they basically ask me if they can have my report, then I can provide it to them. There was a sort of a super confidential kind of process that was set up so that the housekeeping staff couldn't look at these medical records, but a physician who was logged in that manner could see the child protection team report and could utilize that for either that time they were in the hospital or maybe a subsequent time they were in the hospital. That doesn't really occur the last 4 or 5 years or so, but that was in place at that time.
But your report would not have been placed into this portion of the chart you're referring to until you actually rendered it, completed it, and signed it much later, correct?
Typically correct, yes.
Okay. Typically. Interesting.
When you are in private practice, when you're managing a patient, let me ask you this way. When you're managing a patient in a hospital, whether it's Bayfront or Johns Hopkins or wherever, and you call for a consultant, a specialty consultant.
Yes.
What typically happens? You get a consult report in the chart?
Right. I mean, I had many years of experience, like as an actual in-hospital person, and that's what's typical. A consult order gets written. In this case, it's different because there's no consult in the All Children's medical record for a child protection team evaluation. That has to go through the child protection team and child protective investigations in the state of Florida. So there's never a consult order for a child abuse evaluation from a hospital physician. What they do is they make a report, or their typically social worker that's involved with the case makes a report to the hotline. That's how it works in Florida. That's how it works at All Children's.
So during the time that Maya Kowalski was at All Children's, did you ever write an order in her chart?
No, I did not.
Did you ever write a progress note in her chart?
No.
Did you from time to time talk with the physicians that were caring for her?
Yes.
But did you see her or round on her on a day-to-day basis?
No. I saw her one time, I believe on October 13th, 2016, and I saw her one time in early November, probably between 5 and 15 minutes each time. Those were the only times I ever saw her while she was in the hospital.
Okay. And what was the purpose of your seeing her those two times?
So part of my medical evaluation is supposed to be a physical examination. So when I saw her on October 13th, I was trying to perform a physical examination, which basically she declined. So in November, again, as part of my job as the Child Protection Team Medical Director, I'm supposed to do a physical examination, and I'm also supposed to provide photo documentation for investigators and whoever else is involved in the case. So I went that day in early November to try to take some photographs of her lower extremities in terms of trying to essentially document the absence of a problem.
And did you take any such photographs?
I did not.
Did you ever interview Mr. or Mrs. Kowalski?
I took, as part of my medical evaluation, I took a fairly extensive history from Mrs. Kowalski and a much more abbreviated history from Mr. Kowalski. The meeting with Mrs. Kowalski took place on October 11th, 2016, and the relatively brief interview or history taking with Mr. Kowalski occurred on October 13th.
Okay. Did you ever speak to the two of them together?
I did not.
When you spoke with Mrs. Kowalski, first of all, where was it?
So at that time, Maya was still in the pediatric ICU. They have a family conference room kind of thing outside of the main entrance to the pediatric ICU. And because of the investigation that was being initiated and everything, I scheduled a time where the child protective investigators and the people in law enforcement that were investigating the case could join me to while I took my medical history. So there, as I recall, there were about 5 of those people, 2 or 3 child protective investigators, I think 2 law enforcement people, and Mrs. Kowalski. They were all in that room already when I got there for the scheduled meeting, which I believe began at 5:45 in the evening on the 11th.
Okay. Did you identify yourself to Mrs. Kowalski?
Absolutely.
How did you identify yourself?
I always say, I'm Dr. Sally Smith. I'm a pediatrician with the Child Protection Team. And that's what I said to her.
And the other folks who were there were either law enforcement or child protection investigators?
Yes. It's possible one of the nurses was in there, but otherwise those were the people that I recall being present.
Okay. Were you wearing a lab coat?
No.
Do you ever wear a lab coat at All Children's?
Well, at All Children's, no. I do in my office now since the pandemic, but for 20 years, I never wore a lab coat.
Do you wear, when you're in a hospital, do you wear a particular identification badge?
Yes, I have to wear my Johns Hopkins All Children's identification badge to come in the door and to, move around. There's all these little things you put your badge up to open doors. And I have a similar one for Bayfront.
Okay. So if you're in Bayfront, for example, you wear a Bayfront badge. If you're at All Children's, you wear an All Children's badge.
Correct. And when I go in between, I switch badges.
Okay. When you spoke with Mrs. Kowalski, was there any question that you had identified yourself as a member of the Child Protection Team?
Absolutely none.
And did you conduct that investigation in any way as an employee or agent of All Children's Hospital, or Johns Hopkins All Children's Hospital?
No.
Did you ever hold yourself out to Mrs. Kowalski as acting on behalf of Johns Hopkins All Children's Hospital?
No. As I said, this was a scheduled meeting. Everybody knew exactly what was happening.
Did Mrs. Kowalski know?
Absolutely.
How do you know she knew that?
Objection. Speculation.
Sustained.
Are you aware of how Mrs. Kowalski might have known that this meeting was going to take place?
As I said, they were all in the room when I got there. So she, and I believe some of these people had already interviewed her as part of their investigation. She probably recognized some of these people. They got on their badges and their, work-related clothing and things like that. So,
objection. Again, speculation as to what the other recognized.
She overruled. She can say what she saw.
So, and I introduced myself. I don't quite see how it's possible that she didn't know who I was and what was happening.
How long did that meeting take place?
About an hour and a half.
And you subsequently had an opportunity to speak with Mr. Kowalski?
Yes. So.
I'll follow up on that. When did you talk with Mr. Kowalski?
So that was on October 13th, and I'm honestly not sure exactly what time.
Okay. And how long did that discussion or meeting last?
I would guess about 10, maybe 15 minutes.
And who was present for that meeting?
The bedside nurse. I'm pretty sure she was still in the ICU that day. And Mr. Kowalski and Maya.
Did you identify yourself to Mr. Kowalski?
Yes, I did.
And how did you identify yourself?
I said, I'm Dr. Sally Smith. I'm a pediatrician with the Child Protection Team.
Okay. And did you at any point advise Mr. Kowalski that you were acting on behalf of Johns Hopkins All Children's Hospital?
No.
Were you attired in much the same way as you were when you spoke with Mrs. Kowalski?
I was wearing professional street clothes both times.
Okay. And again, no lab coat?
No. I would have had my badge on both times because I was in the building, but otherwise just professional street clothes.
Now, at the time that you spoke with both Mr. and Mrs. Kowalski, and I think I'm getting the dates right, around the 11th and the 13th of October, respectively, were you aware of any efforts being made to transfer Maya to another institution?
So I would say during that week, I knew that was being investigated by, I believe, the hospital. I can't tell you exactly what day I knew that, but I definitely knew that there was an effort being made to transfer her to an inpatient intensive rehab facility.
And were you involved in that effort at all?
No.
Were you directing that effort at all?
No.
Were you directing any of the medical care of the patient at that time?
No.
How did you know that was going on?
That's why I'm not sure exactly the time frame. I know that week, there was a multidisciplinary staffing that took place with people from the Sarasota County investigators and child protection team and myself. And I believe there was discussion at that meeting. I believe that meeting was on the 13th, but I'm not 100% sure. But there were multiple discussions that I had with the treating physicians at All Children's that they were trying to make that kind of thing happen.
Okay. And did you have any understanding about whether there was an effort being made to wean Maya Kowalski's medication or reduce her medication as part of that effort?
I did not really, have any involvement with any of that. I believe at one point later in October, maybe right around now, October of 2016, that I knew that was happening.
Okay.
Let's focus on the testimony, not appearance.
Once again, did you learn of that from the physicians directing her care, or did you attempt to direct that care yourself?
I learned that from communication with the attending physician.
Okay. And do you typically follow that as part of your statutory duties as child protection team medical director? In other words, follow the course of the patient's care.
Yes. Typically when I've seen a child, and then as I'm writing my report, I kind of go back in the chart, see what's happening, put some of the quote-unquote hospital course into my report, and then, reach the conclusion. This was a much more extensive, lengthy process, so at that point at the end of October, I hadn't, done any report or anything, but I was still in communication with them related to what was happening with the child abuse part of the case.
Okay. Now, let me ask that we put up Trial Exhibit 2123-723 in evidence. And let me ask you to take a look at this, Doctor. It's an email from Kathy Beatty. Do you know who Ms. Beatty is?
Yes, I do.
And did you, in fact, make a request of Ms. Beatty to get together with the treatment team to talk about Maya's upcoming needs in December?
Sorry, I got my stuff in front of the screen.
She has to move all her binders.
Yes, so I believe at that time I was in communication with the dependency attorneys, and there was a need to...
You can answer that question.
There was a need to present to the judge what options he could consider and choose from in terms of what the child's needs were, what the options might be for those kinds of treatments and things, and
Let's wait for the next question, Dr. Simonson.
Yes, let's
maybe approach on that.
Okay, so there's a bit of approach, a sidebar here. This is I appreciate you guys focusing on the testimony, not appearances. Or I know there's a lot of people that don't have kind feelings for the witness, but she's doing a good job. She's answering the questions, doing what she should, and honestly, put yourself in her situation. Not with any behavior or things she's talking about, but testifying just in court by herself. In any situation, in front of TV cameras, a jury, protesters outside, knowing a hostile cross is coming. I think she's doing a fantastic job. The actual testimony, though, that's going to be what we address on cross. And let's see what the jury wants to go with as well. Let's see. Lots of people. There's Jules. She's moved over to make some room for some people.
Sustained. Members of the jury, you're going to disregard the answer that Dr. Smith was just giving. Mr. Hunter will ask a different question.
Let me ask a kind of a bottom line question here first.
Hold on a second. Can I see the attorneys again?
Judge calls a sidebar. That white noise is what everyone in the courtroom hears right now, so even on Zoom we can't hear what's being discussed. Don, Jules did say that there was at least one person there who was planning on protesting. Emily, we've got the chat slowed down about as far as we can. The problem is we have quite a few members on the channel, which we're extremely grateful for. Thank you. And members do not get slowed down. It's one of the perks of a membership is there's no slow mode for members. All right, this part about her viewing the testimony and the records. I've never been a doctor, but I have worked in the government with clearances, government security clearances, and even though I held the top secret SCI clearance, it didn't give me the right to go through and pull up the NSA pictures of the audio files of whoever they're spying on. Just because you have the technically the access or the level of permission to look at something doesn't give you the right. In the clearance world, we'd call that a need to know basis. You only get to see things that you need to know based on your job. It sounds like there was a similar thing in the medical profession.
You may continue, Mr. Hunter.
Hey, please go ahead. Thank you, Your Honor. Going back to this exhibit, had you asked to meet with the treatment team at this point?
No. I was making that request in my role as the medical director for the child protection team to assist with that side of the situation.
Okay. Were you a member of the treatment team?
No, and I didn't attend this meeting.
Oh, so you wound up not attending this meeting?
It wasn't for me to be there. It was for them to have the discussion.
Ah. And you wanted to know what their consensus was. Well, I mean, strike that. Never mind.
Whatever that was just threw Mr. Hunter off briefly. I'm not sure if he wasn't expecting the answer or if... This is interesting.
Did there come a point at which you became aware of any pictures or videos being taken of Maya?
Yes.
And tell us in general how that came about.
I'm not sure from the standpoint of the treating team at the hospital. From my standpoint, that was related to attempting to have some photo documentation as part of my evaluation and that could be available as part of the investigation.
Was it your understanding, well, did you have any understanding of whether the treatment team desired any such pictures for clinical reasons?
I believe so, but what I can speak to is what I was doing, or my role with it, and my role was related to this attempt for some, in this case, video documentation for the purposes of the investigation.
Okay. So was there ever any point during this patient's entire hospitalization at which you were part of the treatment of the team rendering clinical care to Maya Kowalski?
No.
And did you ever hold yourself out as such to the parents?
No.
That's all I have for now, Your Honor.
Here we go. Let's see if he comes out swinging. I think he's going to come out swinging. Definitely predict some argumentative objections.
Dr. Smith, how many times have you testified in court?
Probably over 300.
And how often have you met with defense counsel?
Well, pretty often, because usually there's a deposition in cases where I'm testifying. Oh, this one? 0.
You did not meet with Mr. Hunter
I did
yesterday?
not.
Did you have phone conversations with him?
I did not.
And not an email?
No.
In the week before, did you?
No.
How did you know to come here today?
Because my attorney from Suncoast Center's insurance company told me to.
Are you still doing what you were doing in 2016 to this day?
I'm a pediatrician. I resigned from the child protection team last July.
You wear several hats, Fifth Avenue Pediatrics, private pediatric practice, right?
Yes.
And then back in 2016, you were more or less director of the Johns Hopkins child abuse team, right?
They don't have a team. They had residents that came to our clinic to learn about child abuse pediatrics once or twice during their second year of training. And I was the designated director for that rotation for them. And if we had maybe 5 or so over the 20 years I was the medical director, residents who came and worked with us for a month, so I would be the person that would be supervising them for those rotations.
All right, so you're in charge of the residency and
for those things.
And so you were considered at this point by Dr. Tepa Sanchez as the go-to person for Johns Hopkins insofar as the
sustained.
Have you ever heard that you were referred to as a go-to by the doctors there?
Well, they wouldn't be saying that to me, so I'd have to say no. I don't know what they say amongst themselves.
Okay. Now, you said, though, that you weren't a part of the treatment team. Did I understand your testimony?
I was not.
Here?
Correct.
Can we bring up Exhibit 1002-0005? Next to the last paragraph, bottom sentence.
I'm sorry. Oh, okay. I see at the very top. Barely see the discharge summary note. Okay.
All right.
Okay.
Now, you weren't and didn't have any training in psychiatry, right?
Just rotations in medical school and residency.
You were not a pediatric psychiatrist?
Certainly not.
You were not a pain specialist?
No.
You were not an anesthesiologist?
No.
You were not involved in rehabilitation medicine?
No.
But you were included nonetheless in this treatment team, were you not?
No.
Let's go to 002-0006. And let's look at the bottom paragraph, third line. I think it's the last of the second and top and the third sentence. Nope. No, above. No. This is at 0006, and I'm looking for the. All right. So, Dr. Sally Smith was heavily involved in her care. Is that true?
As the medical director for the child protection team in a complex medical child abuse case, yes, that's correct.
Well, you were involved in considerably more than that, were you not?
Not in any type of day-to-day treatment of the child, but certainly in a role coordinating some of the elements related to the investigation in the court case.
Well, getting Maya Kowalski off of all of her medications is not part of your job with CBT, is it?
Well, so that was...
Isn't it? Yes or no?
Excuse me, Your Honor. What is the answer to the question?
As soon as she says yes or no to whether it was or was not part of her
Why
job.
don't you answer the specific question? If you need to explain, you can start explaining.
I'm sorry, could you just state the question again one time?
Sure. Well, deciding what medications Maya Kowalski should be on or whether to take her off of medications is not part of your job description at child protection, is it? Or was it?
The part about...
Or no?
Yes, but I have to explain.
Yes, it's part of your job to do that, to manage Maya Kowalski's medications.
May I explain?
Well, yes.
So the part that was part of the question was related to taking her off medications. In cases of medical child abuse, one of the things that is important to try to do in a controlled setting like a hospital is if a child is on medications that may not be necessary, that the treatment team would consider to wean those medications in that controlled setting.
All right, so were you part of the treatment team or not?
I guess it's sort of threading the needle. I wasn't writing any orders. I didn't tell them which medications to stop or wean or anything like that. But as part of the whole evaluation of medical child abuse, there's a component of what happens when they aren't getting all these medications. And so that specific little part of it was within my role.
Exhibit 2116, please. Now, you just told them to get her off as many medications as possible. Down, number 15, next to last from the bottom. I think there's a misspelling there, but we can agree.
Yeah, I believe the legal term is
text from you?
Yes, it is.
Paula Dees?
Yes, it is.
The Paula Dees that testified, well, you wouldn't know. Probably are, but is that as many meds? It just says mess here, but it's supposed to be meds as possible?
Yes, and her reply is the last one's going off today.
Okay. So were you or were you not advising the treatment team, as part of the treatment team, to take Maya Kowalski off of all of these medications?
I was assisting them from the standpoint of the medical child protection team, medical child abuse realm. And as the reply makes it clear, they were already doing it, and I didn't even know they were. So certainly wasn't directing that process.
You didn't know what they were. Weren't you involved in Maya Kowalski's lab results as well?
I'm not sure what you're talking about.
Exhibit 1001-0317. On November 15th, 2016, with Dr. Pagan, as part of the child protection, the treatment team, did he consult with you about an extensive chart review and recommendations?
So again,
I'm just asking whether he did or didn't.
Well, clearly, I believe I had some discussion with Dr. Carroll, who she's one of the hospitalists, and so that's her note. So clearly we had some discussion about documenting that certain lab tests presumably were now normal that had been abnormal, but I didn't order the tests or anything like that.
Are you saying that where it says in a progress note in the Johns Hopkins records, which you say you have access to, right?
Yes.
It says that the treatment team leader spoke at length with Dr. Sally Smith, you, right?
Yes.
That you had done an extensive chart review, right?
Yes.
And you were making recommendations regarding lab tests, right?
I was, from the standpoint.
And you were making observations of whether they were abnormal. Is that right?
I knew she had abnormal tests that I had seen in all these medical records that I reviewed. But I don't, I mean, I'd have to look up and see. I don't really recall if these lab tests done in mid-November had any abnormalities.
A CBC, a CMP, a UA, a lipid panel ordered. Lipid panel is to check her cholesterol level, is it not?
Right. At one time, hers was 363, I believe, quite elevated at various points.
So now you're in charge of her cholesterol as well? Is that right?
The lab tests had certain abnormalities that, based on my record review, I suspected were related to medications and potential toxicity. And so in evaluating the medical child abuse, one of the things we're trying to assess is if harm has been done, and hopefully it's reversible. So that was the thought process, the mindset that I was approaching this discussion with Dr. Carroll.
You're not a pharmacologist, are you?
I'm not.
Also, an IG profile. What's an IG profile?
Immunoglobulin.
And an IgE?
So that's a specific one of the immunoglobulins. There are A, G, M, and E.
And a RAST test to check and see if she had allergies?
Correct. That was one of the things in the medical records that was said to cause some of her symptoms.
Are you an endocrinologist or an allergy expert?
I see a lot of children with endocrinological and allergy problems in my general practice, and I saw a lot of them in my role at All Children's for 12 years, but I have neither board certified specialty.
You don't have a specialty in either one of those, do you?
I just said that, right.
And you were worried about her dog dander allergy, right?
Yes.
And dog dander allergy is clearly part of Munchausen by proxy, right?
It is.
Yes.
They don't like this. This is very. She's blurred the lines. I'm sorry. I just have to start a recording for another court case right now on another computer. Just 1 second. We'll get that done. Recording to there. Have audio and go. All right. There we go. All right. Thank you to the new members who popped in there. We've got a couple of them. Feral Dragon, Gretchen Lynn. I think we had I'll click on them here. Feral Dragon and Gretchen Lynn. Thank you very much. I think we got Gingy Probs earlier. I might be clicking on that one again. She's blurred the lines. Her testimony has made it very difficult for the hospital to draw a clear distinction between what she did and what.
No, I was just sustaining that objection.
All right. And on December 13th, 2016, I realize you might recognize a lot of the dates, but to put it in context, by December 13th, 2016, now Maya had been at the hospital for what, 1, 2, almost 3 months?
October 17th to December 13th would be a little over 2 months, right?
Right. And you were still on the team, were you not?
I was still the medical director of the child protection team.
Well, you were part of the treatment team, were you not?
I was not.
1001-0200. Did you or did you not confer with the team regarding creating a behavior chart? Bottom last 2 sentences. Highlight, please.
So,
did you or did you not become involved in creating a behavior chart for Maya Kowalski?
looking at this note, I think I misspoke earlier. The way that I didn't see any of these ahead of time. But the way the email was written, it was that they should meet, but it looks like I probably did actually attend that team meeting. And so it looks like these were the things that were discussed related to coming up with this list of things that would potentially help the court that was involved at the time.
You just said you hadn't seen these prior to this. Why would it be important for you to see all of these notes in the medical record prior to this if all you're here to do is tell the truth about what you know?
Objection, Your Honor. Argumentative.
Sustained.
And then you had the pain team on documenting pain weekly. Is that right?
Well, I mean, it speaks for itself. These were the things that they said we talked about. I don't have an independent recollection of this specific meeting, and certainly I've been reviewing a lot of stuff the last couple of weeks, but I did not see this nor Kathy Beatty's email ahead of time, so I'm just going by what I'm seeing right here at the moment.
Okay, so then you were involved in changing the room?
Yeah, I'm not really sure what that's in reference to.
Was that changing the room to the 48-hour room, the surveillance room?
No, that was back in November. So
I'm sorry. Go ahead.
I was going to say I'm not sure what this is talking about.
Okay. So were you aware that during that 48 hours, Maya Kowalski was forced to urinate and defecate on herself because she could not get over to the commode?
Objection, argumentative, and facts not evidence.
Overruled. She can answer.
No.
Were you part of the decision to put the commode just out of reach of her so that she could not get to it herself and had to rely on a nurse?
Absolutely not.
Were you part of any decisions to make sure that the nurses moved slowly so that she would be forced to have the decision of either urinating on herself or worse, or, I guess, calling and waiting?
No, I have no idea about that or what you're talking about.
Would that be child abuse?
I think that would be a stretch.
Sustained.
All right. So, if we go back then, as you were talking about, that was in December. If we go back then into October, were you again part of the treatment team with Dr. Hart, Dr. Elliott, and Dr. Dees?
No.
1001-0429, please. Right above the line there, please, and that right there. Now, please take a look at it, read it if you can.
Yes, I have.
All right. And here, Dr. Dees states that she spoke to you along with Dr. Hart and Dr. Elliott. Do you see that?
Yes, I'm pretty sure this is in reference to a meeting that we had on this, I think it was that day, on October 18th. One of the things that's recommended in evaluating medical child abuse is to meet with the treating physicians and discuss what their observations are and everything so that I can then convey that in my report that I wasn't just sort of like out there rogue making this diagnosis, that there were other physicians with some of these other areas of expertise that I had discussed the case with and had the opportunity to hear their expert opinions. So Dr. Hart was the rehab physician, Dr. Elliott was the anesthesiologist, and Dr. Deese looks like would have been the hospitalist that was the general pediatrician taking care of her at that time. So that was the purpose of that meeting.
Well, it says here that the purpose, the first one, was continue with the current plan, right?
I don't think that's what it says. I think it's those are two separate things.
Right. Well, wouldn't a treatment team be the team deciding about keeping with the current plan?
Yes, and I think that's what Dr. Deese was referencing. So this is her brief note at the end of the pediatric residence note, and they will put in a few sentences, sometimes more, and so I think there are three separate sentences here where two separate sentences that she added to, convey what her plan was for that day as the attending physician.
Mr. Whitney's bringing up a note to Mr. Anderson right now.
I was just simply asking you whether you were part here of a note in which the current plan described there was discussed.
I understand, I think, what you were asking, and I'm answering the question to the best of my ability.
Okay. You're aware that on October 8th of 2016, there was no active state investigation of the Kowalskis.
I'm not sure exactly when the report was made, but I think at least part of the day on the 8th, that is correct. It was either late that day or the following morning. I found out about the case the following morning. So the 9th. Yes.
So what were you doing accessing Maya Kowalski's private confidential medical records on the 8th if you were just part of the child protection team and there was no investigation?
I was doing so under HIPAA's what's called TPO exception to the confidentiality guidelines, which allows for...
Objection. Move to strike for legal conclusion as to what the statute says.
And they're going to approach. She's definitely got a prepared answer to this. She knew exactly which binder to open and pull a paper out regarding this. I wonder if Mr. Anderson is probably not going to request all these notes, but he has the right to. As soon as she takes out notes and consults them for any answer, he can ask to view them and admit them as evidence. AZDCS Oversight Group, welcome to the gallery. Thank you. Also, Cheryl Bybee, welcome to the gallery. Huge and Cloudier, thank you for the 10 gifted memberships. I appreciate that. Purple Haze, 11, thank you very much, of 4 months of support as a member as well. Appreciate all of you. It's he's threading the needle. He's walking the line. I do not think he's worried about time right now. He's going to do everything he needs to get the answers out of this. This is one of the witnesses that really makes the hospital look bad, especially because that line that separates this witness from the hospital is blurry, and the witness has admitted it's blurry, and there's no clear-cut separation, and because of that, the separation regarding a culpability is also blurred. So we're going to see him push this, and probably we're going to see a lot more objections. That's what we're going to see. You guys, we've got a lot of people in chat. If you see a comment that echoes yours, you don't need to type the same thing. It scrolls so fast right now that almost no one's comments can be read at all. If you got something new to contribute, that would probably be the easiest way to put it in chat. But 100 people saying one thing and 100 people saying the other is going to make the chat fly so fast that we can't read any of the comments. So just be use a little bit of forbearance when it comes to chat. Just let's go light in here, just so that all the different ideas can be presented. All right. And thank you once again. I appreciate you guys focusing on the testimony. If you don't believe the testimony, that's great. We don't want people saying, "Oh, she's lying" or "she's not telling the truth," whatever. That's for the jury to decide, and we can have that discussion outside of that. But during the testimony, let's focus on what she's saying and the actual facts of the testimony compared to what we've heard before. If there's a difference there. Crazy that she's testified 300 plus times. Well, her job, that makes sense with her job, honestly. With what she's involved with, she's probably testified in almost every single case that she works with. That would be normal. Jury questions are going to be epic. And most likely I'll be able to listen to those as they're read and discussed by the judge, and I'll repeat what I do before. What I try to do here is I repeat verbatim what the judge says as he's reading the questions to the lawyers, because he'll often turn off the sound in the courtroom, the court broadcast will turn off the sound, but the courtroom audio is on. We're still allowed to listen, and I can repeat it. I just can't let you hear that audio directly, or I can't show you the Zoom feed as well. So we'll try to do that as well, so we can get a good idea of what the jurors are thinking, even with the questions that aren't coming in. So I'm prepping my voice for like 25 pages of questions. Let's see, the HIPAA, the TPO exception, it allows healthcare orgs to use and share patient info for treatment, payment, and operations without patient authorization. Thank you, Random Ghosty. That's what she was referring to here.
I'm going to sustain the objection, Mr. Anderson. You can re-ask the question, and we'll get to a break in just a couple minutes. Mr. Anderson, within 5 minutes, we need to take a break.
So, true or false, you accessed Maya Kowalski's medical records on the 8th.
I did.
Prior to that, you did not contact Jack or Beata Kowalski. True or false?
Correct.
Is it not true that you often walk in after...
Mr. Anderson, if you're going to a different...
I am.
Then why don't we take the break now? Members of the jury, do not discuss this case amongst yourselves. Do not do the investigation and receive more information. Let's try to keep it to a 10-minute break. All rise.
The judge has been very good at keeping a schedule with this jury and not going over it. The worst part is in the mornings when they have a lot of work and the jury's a little late coming into court. He's been frustrated by that. But as far as the breaks go, the lunchtime and leaving at the end of the day, he's been very good at having some pretty hard stop times. I'm sure the jury appreciates that. A judge that's mindful of the juries is awesome. I love it.
One of the jurors needed a break.
Yeah, I saw it.
Okay, one of the jurors asked for a break as well.
Dr. Seismith, you're in the middle of your testimony, so you're not allowed to talk to, well,
sure, I'm aware.
Either side.
I'm aware.
Okay, 10 minutes. Let's keep this no more than 10 minutes.
Yes, sir.
All rise.
Okay, 10 minute break coming right now. Yeah, this cross is going to continue. I think Mr. Anderson probably will spend at least an hour on cross, is my guess. There's so many areas he has not gone into yet that he might want to touch on, especially if it triggers something in the minds of the jurors to ask a question. I think he's at a point where he can trust the jury to do some of that work for him, because he does have to be mindful of the time as well. He only had 5 hours of time left when he began this morning, and he's eating into that. Very important cross, though, here. Hope Jules calls in. I'm not sure. I didn't see if she's left. Let me see. Looking on Zoom. Looks like she is outside of the courtroom, so she might call in. I'll watch for that if she does. Interesting. What do you guys think about the witness basically saying, "I've never talked with the defense. You know, I haven't prepped myself with the defense. They haven't told me anything. I didn't meet with them." And he says, "Well, how did you find out you're supposed to be here?" "My lawyer told me." Was that a surprise? Did Mr. Anderson not know that? Because I don't see what benefit those answers were to him. That would go to to further the point that the defense has said that she's not with us. She's not one of us. We're separate. Let's see. Debbie says, asking to get in chat is so fast. Defense called Sally Smith because they want to drive home. She is not an employee of JHatch. Not too worried about that blowing up on cross. Well, Sally blurred that line on cross. She's like, well, it's a gray area, I've got these two hats that I wear, and sometimes it goes a little into the other one, sometimes it goes a little to the other, and then Mr. Anderson jumps in follow-up with document after document talking about medical treatment of Maya. And, her cholesterol levels, her tracking her behavior, things like that. Things that are sort of pretty far. It's a stretch to say this is part of the child protection team's direct responsibility and role. Sally Smith has found a way to tie every single answer back to that. But the way she's doing it, her role, there's nothing she wouldn't be over at this point. There's no pot she couldn't dip her finger in and say, yeah, that's part of my job as child protection, the child protection team. So medications that Maya should be taken off of, that's because those were the medications that were harmful. He hasn't gone into the list, but many of them were, completely different. We're not just talking ketamine here. It's surprising. I think the jury is going to have a heyday with that, and we'll see the questions here after his cross and redirect is over. All right. Her 5 binders is a ton of data. I'm sure they have all of them, but just interesting. She was probably prepped by her own lawyers, definitely. 100%. It would be, you wouldn't want to pay a lawyer if they're not going to help you prep for court. She has a lawyer. That's what they're going to do. Okay. The medical aspect in her role is relevant, says AT1. KCAT says you cannot access a patient's chart in EMR, the electronic medical records, unless it is your patient, not even your own medical records. Every access leaves an electronic signature. KCAT, that electronic signature document, and it's like, 9,000 lines of data, has been admitted as evidence. I think that entire document came in with a lot of evidence that the defense did not want in. But if I remember correctly, that is in it. And part of those entries does show that exactly when Sally Smith accessed the records. And because that access happened outside of the time before she was sort of requested by the courts to come in, which would grant her authority to do a lot of the things that she was doing. Before that happened, because she accessed that, she has to say why she was able to. And the fact that she used her other hat to say, I can take a peek in advance at what I anticipate is going to be coming through the court channel, that's where the line was blurred. She tiptoed over onto the other side of the line and took a peek in advance at what was coming to sort of start building this, and that's gonna hurt her testimony as well as it's gonna hurt the hospital. Okay. Did they catch the guy? Talking about the Maine, what I've heard is that the suspect is still at large in that Maine, the tragic, the active shooter situation we followed last night that's now turned into a manhunt. He's still at large. All right. You guys, I am asking the mods to just remove comments that are in all caps. They take up more space. The spacing of the letters, they take up more space, and when we have so many people in chat, it just makes chat fly even faster, as well as emojis. They're very space intensive, so if you use a lot of emojis or all caps, we're just trying to remove those just to help us be able to read the messages as they come in. So if your message got deleted, just go ahead and enter it in lowercase, and that will help us out a ton. Also, review of records are on an as-needed basis, and at that point, I don't think she could articulate a need to do that. Her saying that there was a TPO exception is interesting. Sally Smith on Zoom just returned back to the witness stand, so she's here. We've still got the lawyers are all there. Mr. Hunter's not there that I can see. We've just got Carell's, Mr. Anderson, Ms. Lawrence, Mr. Shapiro, So they're prepping to continue. So that was a quick break. Lynn says, I was the designated geriatric specialist for our county for several years. Peers called me for consults often. I listened. I never pulled up MedRecs if they weren't my client. This would be, if you can put it in another scenario, I realize most people don't have the security clearance situation, but imagine a police officer who has in their car a computer, which the computers are tied to some very powerful and large databases. It would be inappropriate and illegal in many cases, I think in many states, for that police officer to just pop in his car off duty and be like, I'm just going to pull up, my daughter's dating some guy. I just want to see if he's got a criminal record. I'll just run a quick check, see if there's any outstanding warrants. Neighbors moved in next to me. They're playing loud music. I'm just going to run their license plates on their car and just see, if they've paid up all their tickets. Or that would be somebody who has authority to do something, or at least access to do something, but the authority is only granted on as-needed basis. For a police officer, they can't just run records checks on whoever they want. There has to be that reasonable suspicion. They have to have a reason to do that. And for the doctors, it's the same for accessing the records, and that's going to hurt them. My dog Clover says, TPO exception allows healthcare organizations to use and share patient information for treatment, payment, and operations without payment authorization. Not my opinion, the law. Okay, so healthcare organizations, right? Are you saying that she was acting as a healthcare organization? Because that puts her into the treatment group, right? That puts her on the treatment team, which the hospital's trying to say she was not. She accessed it as the child protection team side, which she didn't have the authority to do yet. So even with the TPO exception, I don't know how that could help. I don't think that's a get out of jail free card. Courtney Meek, I'm not focusing on the time right now. I am, in theory, a little bit. I'm not as worried about the time, but because I think this cross is so crucial to the plaintiff's case. I think this is what they should focus on. Judge is coming back in right now. So here we go. Buckle up, guys.
While we're waiting on that, we checked and we didn't have any objections to the counter designations in Dr. Bose. So we'll get that to the advice.
Great. And then how about O'Leary Johnson?
Oh, I'm sorry. I meant O'Leary Johnson. I said Bose. I meant O'Leary Johnson.
Great. So there's nothing more with O'Leary Johnson that I have to do.
That's correct.
Great. Thank you. Do we know where Mr. Hunter is? Or?
You want me to find him, John?
I'll just give another minute or two.
I can tell you there was a line of age.
Mitova, the judge has brought this out, saying she did this before she had legal authority to do so. That was my opinion. Something I picked up listening to the judge talking about these issues in arguments.
While the jury's out.
Well, Mr. Hunter's not here.
Yes, sir.
Is this a conversation that we need Mr. Hunter for?
I only wanted to mark what the doctor brought in.
Why don't we wait for Mr. Hunter at that point?
Yes, sir.
So what we just heard was Mr. Anderson requesting to mark the notes from the witness that she's accessed.
Let me ask the lawyers this. There's been several references to Dr. Carroll and it's Leslie Carroll. Do we need to say anything to the jury that Dr. Leslie Carroll and I have no relationship, or just leave it alone?
I think they're clueless about that.
It's up to you, Judge. I mean, I don't.
The judge is like, I'm not related to it.
I'm sorry?
It says Judge Carroll.
And as a reminder, my brother is a Dr. Carroll.
Yes.
And so...
It might be a good idea to say something just for that reason. Yeah, because they may have heard Dr. Carroll.
Okay. I don't think it hurts.
So I'll just make that mention. Now, Mr. Anderson, there was another issue you wished to address with Mr. Hunter was here.
Oh, yes. Thank you, Judge. All I wanted to do was mark for identification what Dr. Smith brought in with her to testify with.
You mean all those notebooks?
Well, that's a good point. Man, I couldn't see what you're talking about here.
Let's just talk practical from the clerk's perspective. If Dr. Sally Smith has only looked at like 2 pages this whole time.
Yes, I see the court's.
I have no, I mean, you can mark that.
Yeah, I just think that the binder she has open right now is the only thing I would want. That's the only thing I've seen come out of it is this one binder that is before her right now.
Well, I don't think she's looked through the binder. I think she's only looked at a couple pages in her hand. So
I don't have any issue with her looking at her with marking what she has looked at, but that should be it.
I always thought when they brought stuff to the stand, you could explore whatever they brought.
Well, if she's not looking at it, and it's just more or less a prop, if you will, at this point, I just don't want to have 5 or 6 5-inch notebooks having to be given to the clerk who already has so many notebooks.
She's got quite enough notebooks. Yes, that's what I was just suggesting. Only this one that she has got open right now and referred to. I have not been able to see how many pages, what she's referred to, but I do know that it appears to only be one notebook.
Dr. Smith, why don't you close the black notebook and only keep out what you've actually looked at, which is what's in your left hand. Yes.
Okay.
Okay.
Good.
So, as a reminder, if Dr. Smith is going to look at any of those items, then we'll probably mark that. But just to mark 5 binders, mark them, do not do that.
Understood.
I don't know if it's proper, but all of these are shared documents that are bait stamped, except for a couple of folders with references. And as you have stated, I haven't touched them. So,
and unless and until you have to look at them, let's not worry about it, because I don't want to spend the time having the lawyers go through to check to make sure that there isn't a sheet of paper that isn't in evidence or not in evidence.
Right.
That would take forever and doesn't help us along.
Right.
The other case was settled for $2.5 million.
Is her report material.
Exactly. I didn't realize I wasn't going to need it.
And so I guess the moral of the story is unless you absolutely need to look at one of those items in your binder, let's not go there, because then
you got it.
Adding tonnage to the number of items the clerk has to keep track of.
I don't really want to kill those trees.
Are we ready to bring in the jury? Mr. Hunter, are you ready for the jury? Let's bring them in.
Bring this jury, right? I don't understand why she has this many papers with her to look smart. No, probably, Madeline, I'd say that she has all her records, everything, so that no matter what she's asked, she will have the ability to respond to it and say, okay, let me go back to that note. This is the page. Here's my record. She doesn't want to. I mean, she's brought everything with her in case she needs it. I realized that the defense attorneys did not prep her for this. It was her own lawyer that did that.
Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? Have you seen any media accounts since you were last with us? Has anyone approached you about this case since you were last with us? Mr. Anderson, you may continue. Before I did it, there's been a couple of references to Dr. Leslie Carroll. Obviously, my last name is Carroll. There's no family relationship between Dr. Leslie Carroll and myself.
Subject to redirect, plaintiff yields to the jury's questions.
Whoa.
Well, it goes back to Mr. Hunter now.
We're straight. He's done. He's done.
Please go. counsel ask you about your access to the medical records when Dr. Tepa Sanchez called you?
Yes.
Was that as a result of your being asked to consult on a case by a fellow medical staff member?
Correct.
Is that customary, typical?
Yes, and I...
Objection, foundation, and predicate for that.
Well, the answer yes remains.
Your duties as the medical director of the Child Protection Team, the CPT, if we can.
Yes.
Usually that's the shorthand folks usually use?
That's the usual, yes.
Okay. Is part of your, do you understand part of your statutory duties with the CPT to follow patients who are sheltered under a child abuse investigation?
My understanding and my responsibility is to provide whatever assistance is requested from the investigators, law enforcement, and attorneys that are involved in the case. So that, yeah, I think I'll leave it there.
Okay. And I think I better leave it there. Have we ever spoken?
I believe, I might be wrong, I believe you were at one of my 5 depositions, but other than that, I knew of you when I worked at the hospital, but otherwise, no. To my recollection, no.
Have we ever
When I worked
discussed this
at the
case?
hospital?
No.
Have you ever discussed this case with anyone from my office?
No.
Nothing further, Your Honor.
Mr. Anderson, anything further?
No, Your Honor.
Members of the jury.
All right, I'm gonna start repeating what we hear. As the Zoom's a little bit ahead.
I think there's more coming.
Lots of questions. Given the number of questions, says the judge, members of the jury, I'm just going to ask you to step out. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information. All rise, says the bailiff. Jurors exiting. The jury has binders.
Given the number of questions, members of the jury, I'm just going to ask you to step out. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
Thank you. The jury is out of our presence. Dr. Sally Smith. I need to go over these questions with outside your presence, so I could have you step outside in the hallway. It'll be a couple minutes. So Dr. Smith is leaving now. I'm listening to the Zoom and I'm recounting everything I hear. This is not me using my psychic powers to listen in from thousands of miles away.
Dr. Sally Smith, the
Dr. Smith is out of our presence. Let's start red number 1. Do you know why it is the hospital's policy to contact you first instead of reporting the suspected abuse to the child abuse hotline? Correct me if I'm wrong. There is no harm in contacting the hotline prior to contacting an expert first. That's against court decorum, James. I can't do that. I've agreed to certain terms to have access. And the judge has prohibited that. No objection from either party. Judge is trying to read this next one. Red number 2. How would CPT normally access the medical records? Next question. Do the county CPT have access to to medical records normally without privileges? No objection, says Mr. Hunter. No objection, says Mr. Anderson. Red number 3. Are the physicians that are part of the child protection team required to have privileges at a hospital to provide a medical assessment? If yes, do the privileges grant access to patient medical records? If no, what procedures would a CPT physician follow to obtain medical records? Next question. Is it standard for a CPT physician to offer any recommendations to a child's treating physicians in a suspected child abuse case? Silence. No objection, Your Honor, says Hunter. No objection, says Mr. Anderson. Says the judge. Mr. Anderson said, actually, no problem with 1, A and B. 2 is a bit beyond the scope there for her to testify about the rules and procedures for all CPT positions. I'd object to that. So he changed his mind on that. So we have 1 objection from Mr. Anderson. Mr. Hunter said he made an issue of it. I think it's within the scope of her expertise. I suspect with the scope of her knowledge. And C, that is a follow-up on certain of counsel's questions. Mr. Hunter said, I asked broadly. Judge says, I believe that this question is it standard for a CPT physician to offer any recommendations to a child's treating physician when a suspected child abuse case is covered, whereas within the questions that were asked, and I think it actually goes to the question of whether Dr. Sally Smith was operating in her capacity as the medical director or somehow an apparent agent of the hospital. So I will overrule the plaintiff's objection and ask that one. Red number 4. Who made the referral to your CPT team for the evaluation? When you told Dr. Dees to get Maya off as many meds as possible, did you know that was already in progress prior to telling Dr. Dees to do so? Were all the meds or outside treatments being investigated, parentheses, with regard to the Munchausen suspicion, end parentheses, being administered and provided by Beata or other medical providers? Mr. Anderson says something problems with that one. I'm not sure if it was no problems with that one. Now Mr. Shapiro and Mr. Hunter are looking at it. Long pause here. No objection, Your Honor, says Mr. Hunter. Mr. Anderson comes in and says, no objection to the first. The second one raises this is Whitney, raises the 403 issue regarding medications that were being administered and provided by Beata Kowalski. If we want to strike Beata, we would not object. But Dr. Smith will we'll wave right into the allegations that Beata was administering these medications. Mr. Anderson says that was a definite problem. It says being administered by Beata. Mr. Shapiro says, I'll make a record of this. I think they put up records of Dr. Dees and Dr. Smith discussing medications and what to take child off of medications. Dr. Smith's testimony was, judge interrupts and says, it's just our court reporters having a difficult time. Mr. Shapiro said, I was going to make the record of this. They put up text messages between Dr. Dees and Dr. Smith discussing what medications to take people on or off. Dr. Smith clearly testified in her response that she makes recommendations with that regard so she can evaluate how the child would do if taken off certain of their medications from a child abuse perspective. That's the purpose of the follow-up question. So they've alleged she had no right and no rule to be discussing with Dr. Dees what medications to taper and why she would want this question. Goes to the heart of that. They cannot block that question now if they don't like the response. Mr. Whitney says, okay, well, if you want it to be an instruction for a yes or no question, she can answer it yes. That would avoid the 403 issue. Or we can strike Beata from that question. But as phrased and allowed to expound, it will go straight to everything the court's done to keep out. Mr. Anderson says, I'm going to object to number 3. No objection to 2 or 1. Mr. Shapiro says, with regards to number 3, Your Honor, they specifically asked, and that's been asked regarding Munchausen, they continue to open the door. They specifically asked Dr. Smith, did you think the allergies... Judge says, I'm sorry, let me just deal with what we're calling as number 2, and I just want to make sure when we say number 2 is when you told Dr. Dees to get Maya off as many meds as possible. Did you know that that was already in progress prior to telling Dr. Dees to do so? And defense has no objection. And Mr. Anderson says no objection. Judge says, so there's no objection to 1 or 2? And then, says the judge, let me reread this third one. Mr. Shapiro, do you want to tell me your position on this? Shapiro says, yes, the plaintiff again continues to raise the issue that there was no basis to suspect Munchausen. I won't go back into all the instances they did in opening and with Dr. Newberger, but they directly asked this witness a question. Doctor, did you recommendations of something, dog allergies, have anything to do with Munchausen? They continue to use this as a sword to say that we need Dr. Sally Smith or neither Dr. Sally Smith or the doctors of all children's had any basis for the suspicion of Munchausen. They've done it throughout their entire case. And every time there's a question, the defense counsel, or now this jury, asking what basis was for her to suspect Munchausen, they throw up a massive shield and say, no one can talk about it. They continue to pound this door open of allege that all children's is negligent for this diagnosis, or allege that all children's is, especially their opening statement, they said directly that because of this accusation, Beata lost the maternal instinct to protect herself. And now they try to block the Munchausen's expert, who is going to have one chance to testify from this jury, to tell this jury why she had these suspicions. I absolutely respect this court trying to walk the line, but the plaintiffs keep jumping over it. Mr. Whitney says, Your Honor, we had this discussion on Monday morning, and defense counsel just alleged we're seeking damages for Munchausen by proxy. We specifically discussed this on Monday, and that's the reason why there's no discussion with this witness of Munchausen. Of these 5 binders of information she has, or anything in the report, this very reason. Judge says, well, here's my view on this. This question, textually, is asking about her investigation. I hear what Mr. Shapiro is saying, but I don't see how talking about dog dander or allergies constitutes medications or outside treatments. And so I don't think this question is going to that discussion that Mr. Anderson had with Dr. Sally Smith. I feel this particular question, since it goes to the scope of her investigation and what she was doing in the investigation, is outside the bounds of what we're going to allow. So I will I'm going to sustain the plaintiff's objection, and I will not ask that question. Red number 5. How about this one? In Pinellas County, in all trial protect cases, what percentage of cases do they take the children? What percentage were you involved in? Do you still have medical privileges at Johns Hopkins All-Children's Hospital? Shapiro says, I know what the court's reaction is going to be to number 1 or 2, but I will say that frightens me that someone might have done outside research. Anderson says, we've got at least one nurse that would know, and that would know this without doing any research. We have no objection to number 3, and number 1 and 2. I think my colleague nailed it. Those questions are frightening, says Mr. Hunter. Shapiro says, there's an objection. I think the plaintiff's wrong. Mr. Anderson says, I have no objection. 1 and 2 appear to go to her background. Maybe it's because I asked so many times how she testified in court. Shapiro says, we do object to 1 and 2. And again, I know this court's done an excellent job trying to screen for pretrial publicity, but I put on the record that was the theme of the Netflix movie. So it is alarming to the defense that is coming from jurors. For this purpose of this question, we object to number 1 as well. Judge says, well, to be fair, I have seen so many newspaper articles and commentary years ago about this particular issue. I don't think this is a sole and exclusive Netflix issue. I'm pretty confident this juror didn't even see the Netflix. So what I'm saying is that concept is not Netflix or into that as a sole basis. And I also can see it is a fair implication from Mr. Anderson's question, but whether it's a fair implication or not, I'm going to sustain the objection as to 1 and 2. So we will only ask question number 3, which is, do you still have privileges? Red number 6. Is conversion disorder and Munchausen by proxy somewhat the same or similar? They seem to come up interchangeably. I feel that they are kind of similar, so I have this question. Back in the summer of 2015, when Dr. Rice testified it was conversion disorder, should that not have triggered Dr. Rice to call the abuse hotline? Or was the Dr. Rice call to you what Dr. Rice thought was her duties, and you determined no follow-up needed? Why would Dr. Rice and Tampa General Hospital doctor need to call you about Maya when you were at All Children's Hospital and not her own hospital's CPT? Have you and Dr. Rice ever had past dealings with each other? Oh my goodness. Do you see the look on Mr. Shapiro's face as this question's being read? Whitney says, we'll start with objecting to number 1. She testifies she has no expertise in psychiatry, psychology, is completely outside her scope, and leads into her investigation to talk about the overlap between something Munchausen and conversion. Do you have anything, Mr. Hunter? Says the judge. Mr. Hunter says, I think we have to join. I disagree with those particular objections. The judge says, I can read your rationale. You both agree, and I actually agree on that one. So, Hunter says, yeah, judge says it's unanimous. Ms. Shapiro says, I will say, just to protect record, it wasn't made just in the appellate issues, but the defense may move to try to admit the call to DCF with Dr. Rice. It's been excluded, but that is a question that this juror would have gone to. Knowing that that's been excluded, I would agree with that this needs to be objected to. He's standing too far from the microphone and looking down, so we're not getting the audio the best on him. Mr. Whitney says, so the balance on Bonnie Rice, do you agree that those should be not asked? Mr. Shapiro says, I don't think she can answer that without implicating something that's been excluded from this trial. Judge says, so everything on this page is out, right? Right? Yes, I agree. We agree with the result, but not with, says Hunter. But this one over there, so I don't get confused, says the judge. Red number 7. My notes from Dr. Rice from a January 22nd, 2021 video deposition. I've noted that Dr. Rice of Tampa General Hospital had encountered Maya and in her own words said what Maya had was conversion disorder, not conversion, that conversion disorder was in quotes. Stating Maya had no physical issues, it had to be psychological. And for these reasons, had to call you at JHatch to, quote, raise a red flag, end quote. I believe was, or similar to, what Dr. Rice said. What or how was this 2015, I believe, summer of 2015, conversations, information documented? I don't think that Maya had been a patient yet at Johns Hopkins All Children's Hospital yet in the summer of 2015. But if she was or had been, would the Dr. Rice Tampa General Hospital information be recorded in All Children's Hospital files? Or, as you didn't work for All Children's Hospital, would you have those summer 2015 or Dr. Rice notes in a DCF CPT file? Are those notes in evidence? And if so, what is the number? Whitney says, I think the defense will agree that as to when Sally Smith and Bonnie Rice took place, that would have been as part of this investigation. Once she had the Tampa General records, that would be in the fall of 2016. Anderson says, and she's not a doctor, she's a nurse. And I've heard on more than one question whether Roberta Hearst is a doctor. I think that needs to be corrected. Lots of people talking. Hunter says, the bottom line for the next question, there's a lot of confusion in it, but it goes into matters that the court has already ruled upon. I would like nothing better than to have, well, I would like nothing better. The court has ruled on the Bonnie Rice report, and based on that ruling, that question is objectionable. Shapiro says, let me just ask this before it probably is, I don't know if it is. She asked whether this juror at the end, most of this is going to be objectionable. The juror asked again whether Dr. Smith had access to Bonnie Rice's records and whether those, well, the same question, are they in evidence? The answer is yes. It's yes to both, says Mr. Anderson. Well, says the judge, this is crazy. What about, this is the judge again, what about along the lines of what Mr. Whitney was suggesting, either a question or a statement saying, Dr. Sally Smith, did you have a conversation with Nurse Rice from Tampa General Hospital in 2015? Shapiro says, well, the judge says, just hear this thing out. Whitney and Shapiro are both talking. Shapiro says, I'll tell you the only reason that Hunter says that I think if you start down this rabbit hole, it's going to go all over the place. Shapiro says, it's not just that, Mr. Hunter, says Shapiro. My objection is the defense Bonnie Rice has testified that she called DCF, and I think it would be prejudicial to the defense to suggest to this jury that Bonnie Rice's suspicions of conversion disorder and erratic behavior did not rise to the level of what's necessary to call the abuse hotline, because Bonnie Rice testified she did. Now, I understand why the court has decided not to bring this into evidence. It would be prejudicial to the defense to ask Sally Smith whether Bonnie Rice ever reached out to her, when we would be excluded from cross-examining her with the idea that, are you aware that Bonnie Rice has testified under oath that she did call DCS? So we would object to, the judge says, okay, but the question of when the Dr. Sally Smith and Nurse Rice call happened was in October of 2016, right? Says the judge. Hughes says, I have a proposal. It would be October or November of 2016. I believe so. Well, that is, says the judge, the concept that I think disabuses the apparent confusion. It avoids getting into calls for 2015. Whitney says, judge says, I don't know if it's a statement or a question, but you said you had a proposal. It's Whitney with the proposal. Ask her, says Whitney, do you recall any conversation with Bonnie Rice? Yes or no? If she says yes, when was that conversation? She says 2016. Then that would answer the question from the jury, and we would be done with it. Judge says, without getting into the substance of those discussions. Mr. Hunter says, if you're going to do that at all, I'm not opposed to the idea of getting rid of just the confusion, and just ask Dr. Smith before the jury comes in, do you recall having any conversation with Bonnie Rice? If she says yes, and she's able to identify when, then ask her for those two questions in front of the jury, and that's it. Mr. Shapiro says, the only thing I'd add to that is that she did have access to Bonnie Rice's records. That's not in dispute. Judge says, well, I suppose that's how she found the Bonnie Rice, I would imagine, but it just, it's the question of when that first call between Smith and Rice occurred. And if that call is 2016, Mr. Hunter says, if it's just a matter of, I remember talking to Bonnie Rice, I did so in fall of 2016, and yes, I saw her records, that's it. That dispels the confusion. Judge says, well, let's go through this last question, and then I like the idea of bringing in Dr. Smith before the jury comes in, and then trying to nail this one down. Red number 8. During your testimony, when asked when hospital staff took so long to respond to Maya's calls for assistance to use those facilities and had to go on herself, that is not child abuse? Let me read this again to this judge. Carell says, that was the question that was sustained. Judge says, during your testimony, if/when hospital staff took so long to respond to Maya's calls for assistance to yes the facilities. Oh, use. Well, so the judge says, this is clearly yes. I'm just reading it. It's a clear YES. That is not child abuse. That said, in all your years of CPT/DCF service, you have never used documentation of a person of child's appearance of defecation upon themselves as evidence of at least possible child abuse. P.S. I did when a PO on the scene. Guess who wrote that? Hunter says, that was a question you sustained. Lots of mumbling here. They're looking it over. That is not child abuse, says Mr. Anderson. I think if you put a question mark there, that said they're rereading it over and over. Is it possible child abuse? Yeah, we got to strike it, says Mr. Whitney. The question itself, says Mr. Anderson, is in follow-up to an allowed question and answer, so no objection to either one. Personally, it's kinds of correlate, but Hunter says we object. Judge says I sustain the objection. Will not ask that one. Judge says which one? Anything on that page, says judge. Let's bring in Dr. Sally Smith. I can almost read Jules' notes on the screen. Judge says, we're not asking that. I just wanted to get those out of the way so I kind of can mix them in with the ones, not mix them in with the ones I'm asking. So those are all the questions. And this is going to be a profer outside the jury's presence now. We should get audio here in just a minute as soon as the witness is back on the stand. The witness did leave. She was gone. Judge says, okay, Dr. Smith. Yes, a few questions outside the presence of the jury. Here you go.
Okay, Dr. Smith, I'm going to ask you a few questions outside the presence of the jury. Okay. Have you had a conversation with a nurse, Bonnie Rice, from Tampa General Hospital?
Back in the time of this case, yes.
When was that conversation, to the best of your recollection? And a month and a year is fine. For the purpose of this question.
I would say October into November, late October, early November 2016.
Was there any conversations, to the best of your recollection, between you and Bonnie Rice in calendar year 2015 about Maya Kowalski?
No.
Okay. I'm going to ask you those two questions first, and then I'm going to ask you the rest of the jury questions.
Okay.
Let's bring in the jury. Yes.
Yeah, the security, the sheriff's office is responsible for security in the courtroom, and if there's a lot of public interest on the outside of the courtroom, there'll be more security on the inside. So I'm down 7 objections. We should be at 14:30. Thanks for counting those for me, guys.
Okay, please be seated, members of the jury. I want to confirm while you're away, you did not discuss this case amongst yourselves, you did no investigation and received no information. Is that all correct?
Correct.
That you haven't seen any media reports of this case, is that correct?
Correct.
No one approached you, is that correct?
Correct.
Outside of Dr. Smith's presence, I went through the jury's questions. I'm going to be able to ask a good number of them, but not all of them. Okay. Dr. Smith, have you had a conversation with a nurse, Bonnie Rice, from Tampa General Hospital in connection with Maya Kowalski?
She's a nurse practitioner, but yes.
When approximately was that conversation?
I'm pretty sure it was in late October, early November of 2016.
Have you had any conversations with nurse practitioner Rice in calendar year 2015 with respect to Maya Kowalski?
No.
Next question. Do you know why it is the hospital's policy to contact you first instead of reporting the suspected abuse to the child abuse hotline?
It's an unusual situation, and because of the way that the whole system is set up in Florida, and they have to file a report for me to do a medical evaluation, sometimes they're not sure what to do. And so in those occasional situations, I'm going to say once or twice a year, a doctor from All Children's would call me to ask me a question about the case that they were involved in and request my expertise related to the child abuse and neglect question that they had.
Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
I'm sorry, can you?
Sure. Correct me if I am wrong. There is no harm in contacting the hotline prior to contacting an expert first.
The only situation would be if there potentially wasn't really enough evidence or whatever to justify a report. So otherwise, no, I mean, typically the report gets made before I, as an expert, would be involved. Almost all the time.
How would CPT normally access the medical records?
So I always would access them through my remote access that's granted as a member of the active medical staff. If it was a child protection team, say from Sarasota County, that the person didn't have privileges at All Children's, then what they would have to do would be to, submit a request for the records to the hospital to obtain those records.
Does the county child protection team have access to medical records normally without privileges?
Only because, well, not like I do with it's an electronic access. Another team or somebody besides me would have to make that request, and there's statutory language that requires the hospital to provide those records in the furtherance of the investigation, so they can get them, but they can't just log in and see them as easily as I can.
Are the physicians that are part of the child protection team required to have privileges at a hospital to provide a medical assessment?
I'm pretty sure that is correct. So mine's easy because they're just the one hospital. Other teams, like say for example in Miami, I think the medical director probably has to have privileges at Jackson Memorial and Miami Children's in order to go in and see the child, but I'm honestly not sure because it's not my situation. So I don't know exactly what the rule is with that. I think probably they have to have privileges, but I'm not sure.
So if yes, do the privileges grant access to the patient's medical records?
Yes. So as part of our credentialing, we get re-credentialed every 2 years. We have to do like certain, HIPAA training about medical records. There are rules about which ones you can and can't access.
Really?
And it's pretty closely watched and monitored. And so, I can do that in my role as the medical director of the child protection team, and on these occasional situations where they call me separately because they're not sure what to do and need child abuse pediatrician expertise, I can do it in that role as a member of the medical staff.
Is it standard for a child protection team physician to offer recommendation to a child's treating physician in a suspected child abuse case?
With regards to potentially certain tests or certain needs of the court, yes. So for example, if I'm seeing a child that has a bunch of injuries and they need a follow-up brain scan, I can make that recommendation to the team. Could you please do a brain scan on such and such date? And, typically they're going to do what I ask them to do in terms of that, because it's something I need for the purposes of the investigation and to assist all the various people involved to make a good decision in the case. So I think that answers probably.
They're going to do what I asked them to do.
Who made the referral to your child protection team for the evaluation?
The child protective investigator called a case coordinator that was on call or was the designated person to receive what they call intakes. So when there's an investigation that's been initiated, particularly in a case like this where there's a major medical component, then the child protective investigator calls the child protection team, and one of these case coordinators, or we actually had a person that they called an intake coordinator, takes the information, kind of reviews everything, and then that person would contact me and say, Dr. Smith, we need you to go down and see such and such child at the hospital.
When you told Dr. Dees to get Maya off as many meds as possible, did you know that was already in progress prior to telling Dr. Dees to do so?
I did not.
So she was ordering it.
Do you still have medical privileges at Johns Hopkins All Children's Hospital?
Yes, I still have active medical staff privileges there.
Members of the jury, that is all the questions that I'm going to be able to ask. So, Mr. Hunter, you now have the floor, sir.
Morning again. Could I have trial exhibit 2408-1739 in evidence?
I think Mr. Hunter's under the weather. I think he's not feeling well. I'm not saying that's because of where the case stands. I think
2408, what is that?
He's ill.
Can you take that down, please?
Ryan's their new guy back there putting up documents. Looks like you put the wrong one up.
Is this 11? Yes.
Okay, you lost me again. Wait a minute. This is for your edification, Doctor, this is an email from Beata Kowalski dated 12 October 2016. And I'm going to ask that you go to page 1739, the following page, and then the midway through the second full paragraph on that page, there's a indications Tuesday 10/11 evening. I had another supersized visit from MD Dr. Smith, who was sent by CPS to investigate this case. Would that have been about the time that you spoke with Mrs. Kowalski, the author of this email?
Yes, that's exactly what, and she says an hour and a half, so just like I said earlier, that was that evening that I came down and talked with her.
Okay. There was reference to the EEG video that was taken of this patient.
Yes.
Have you ever reviewed it?
I don't believe so. It's possible at the time I looked at a few minutes of it, but I don't think so.
Were you aware of any indication on that video of Maya Kowalski defecating or urinating upon herself?
I had no idea if that was true or not, frankly.
Did you ever hear any indication of that and suggestion of that in real time?
No.
That's all I have. Thank you.
Mr. Anderson.
Yes, counsel. Yes, or make sure I'm asking the right question.
Sidebar here. There's probably, just with the number of people that are in court, they probably have a little formula, and they're probably not going to release this publicly, but the security measures that are taken at any public building like this, the larger the crowd, the more security is there. That's it. And we've got more people in court with a higher profile witness. People for Real says, this isn't as crazy as I expected. What we have seen is what we saw in the deposition of Sally Smith as well, and she has stood by her guns on everything. And literally, I think at this point, she believes that everything she did was right and acceptable, and that there's no problem with it. The jury seems to be clued in a little bit as to the blurring of the line when it comes to using access the medical record, and asked questions about how the procedure normally works with Child Protective Services, DCF. How does somebody else in her position get that same information? And when she says, oh, there's a process, they make a request, it goes to the hospital has to grant the request because it has the legal authority. Okay, so you connect the dots here. We have these requests, we get sent to the hospital, it has legal authority. In my situation, I can cut out one of those steps, okay, because I have the access, so I just requested of myself. Different team receives that, okay? When those requests come in, a different team receives that than just her. She doesn't grant the request for other people. So that blurring of the line is going to cause problems, I think, for her and for the hospital. Also, when she went on further and was saying, you know, when she answered the question about when you directed them to take them off the drugs, did you know that was happening? She elaborated on that answer and went further to say that, you know, when I make that request, you know, they're going to do it because, you know, we're requesting they have to. It shows the authority, and it puts all her inputs in these team meetings when she provides input and saying, run these tests, monitor for this, we want to check, you know, everything, cholesterol, whatever it is. It puts that into perspective that now she can say, oh, I'm not on the team, but she was controlling the team. She was directing the hospital what to do, which is also outside of her authority. She should not be directing the hospital as to how to manage the care of Maya. So I think even though she's standing by everything, I think her testimony has some holes in it that the jury is going to have some trouble with. That being said, I will say she settled down quite a bit from when she was first here in court, and I was able to articulately testify to everything she's been asked. So good job as to that on the testimony. Okay. Let's see. We've got a few questions we're trying to see. Connie, Dr. G has so much expertise on this that I don't. I can't wait to hear what he has to say. He's probably going to do a couple more videos. I know he's doing a video about Maya. I don't know if he's going to do a second video about Sally Smith and Kathy Beatty. His first video dropped yesterday about them on his channel. So I don't know if he's going to compare the two testimonies. I will say that this testimony was not as shocking and in many ways almost offensive as some of the things or the way she portrayed information in the first one. She didn't have that same air of superiority that came across, at least to me, in the deposition. Lacey Ann says, J. Hatch keeping her on staff is a big no-no to the jurors. Do you think the hospital is trying to shift the blame to her, therefore they aren't liable? Oh, they're clearly trying to draw a line. They're trying to say there's a line in the sand and you are on one side and we are on the other. So if you have any problems with what Sally Smith did, just know she's not one of us. Yes, we give her privileges. She can walk into the hospital anytime she wants. She can treat, see patients. She can access records. She can put notes in the medical file. But she's not one of us. She can attend our meetings and be, chair of some of these meetings that go on the Child Protective team. She can be involved in every way, but that's not us. And they want to have it both ways. They want to say everything she did was as an outside person. We just brought her in on these committees as a civilian, just for an outside perspective, just for our information. But she's testified here that basically her suggestion was law because it is backed up by law. The hospital has to do what these CPT investigators want. She still has practice, a pediatric practice she works at now. Yeah, she had, those are the privileges, but those privileges, I mean, she literally testified. She goes to HIPAA training. Okay, where every 2 years she goes through these trainings that specifically spell out when she can access and how she has to follow the rules to protect the patient's rights. And on dollars to donuts, I'm going to bet you that there is something in there that says you cannot access unless you have need to know, or something to that effect. And yes, she could anticipate that she would soon have need to know. But I don't know how she can blur the line enough to say that without that authority coming from my boss, the call that comes down and says, okay, here's a case, go work on it. Without that authority, how did she do that? How did she have that permission to do that? And I just don't think you'll find it there. She couldn't do it under the TPO exception, in my opinion, as another medical professional sharing information. Because she's not on the medical team. She's not on the medical treatment team. And she's testified to that. So she's using her access on the medical side to perform duties on her CPT side that she does not yet have authority for. And I just don't think that you can mesh those two together and say because I have authority over both these areas, it doesn't matter when it happened. I think it does matter. I think it's key. K-Rab says, Rob is going to do a joint stream with Spidey from Behavioral Arts this weekend, analyzing SS testimony. That is awesome. I can't wait. First, of course, I want to hear how his days in court went, because he's got court trial today and tomorrow. But watching Spidey and Rob tear this apart is going to be fantastic. We'll have to be there. What happened to the lecture? Apparently nothing. And Jolly Rogers, great question. The fact that she's a practicing pediatrician in this area.
Yeah. And Mr. Hunter, do you have any?
It doesn't mean that something was wrong with her doing that. If she had said she was watching the trial, that would have been
any further questions? Seeing none. Okay, members of the jury, I'm going to ask that you be back at 1:45, so just a couple extra minutes beyond our normal lunchtime. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. See you at 1:45.
So they're headed out to lunch, and as they do that, we're going to prep to go to lunch as well. It wasn't as explosive as I expected. It really wasn't, considering how vigorous the plaintiff attacked during the deposition. They did not do that during the cross. They saved a lot of time. I didn't count the exact amount of time, but I think it was less than an hour that they spent on cross, probably closer to about half an hour.
Dr. Smith, there's a couple things we needed to do before we were able to break for lunch. So, Mr. Hunter, you have the floor.
Thank you, Your Honor. Strong judges and clean copies of the reports here.
We're doing a proffer, just so you understand. Okay. Oh, Madam Court Reporter, if you could mark this transcript as the proffer.
Thank you, Your Honor. Dr. Smith, this is a proffer for a potential appellate record, and what I'm going to do is ask you some kind of conclusory questions and some summary questions to avoid your having to sit here for a long afternoon, and all of us the same way.
Okay.
In the process of your investigation of the Maya Kowalski case, after it was referred to you, did you conduct an investigation? Did you gather some medical records?
I did a medical evaluation, including gathering a lot of medical records, yes.
Okay. And did you, in fact, promulgate two different reports?
Yes.
Regarding that. One was a preliminary report in October of 2016?
October 13th, correct.
Okay. And the other was one signed December 2nd, 2016?
Correct.
Do those reports both indicate the results of your investigation and review to that date?
Yes.
Okay. And in connection with your report and your investigation, did you obtain certain medical records regarding Maya Kowalski?
Yes.
And does your report, does the report you signed December 2nd, 2016, fairly and accurately reflect the records that you gathered and then reviewed for your report?
Up until that time, yes.
Okay. And then were there subsequent records you reviewed after that, after you received after that date?
Yes.
Okay. And does your report first of October, I think you said 13th, 2016?
Correct. Yes.
Does it fairly and accurately reflect your conclusions up to that date?
Yes.
Okay. And that would, if we were to walk through that report and what it was based upon, would your indication be that it contained and fairly reflected the outcome and your conclusions of your investigation up to October 13th, 2016?
Yes.
And would it also reflect what you advise, the conclusions and facts of which you advised the court, the dependency court, as of that date?
Yes.
Okay. And I'm going to show you what we're going to mark as whatever the court clerk tells me we're going to mark it as.
What's the next in the series for the defendants?
3328.
For ID?
For ID, it's not coming into evidence.
Correct. This is 3328 for identification. And let me just ask you, is that a true and correct copy of your report of October 13th, 2016?
Yes.
Okay.
Can you hand that to me? Are you finished with it, Mr.
Yes,
Hunter? Madam Clerk, it's two-sided, so just be careful.
And then after you rendered that report of 2006, these are new lips, I'm sorry, October 13th, 2016, after you rendered that report, did you continue an investigation as reflected in the report that you signed on December 2nd, 2016?
I continued my medical evaluation up to that point in December and gathered lots of additional records beyond what I had on October 13th, yes.
Okay. And I have a badly marked up copy of what I'm going to ask be marked for identification as defense exhibit.
Well, is there already a specific exhibit number on that? Down at the bottom, Mr. Hunter, the first page. Look at the first page.
The December or the October?
December.
The December is 3045. 146.
The answer to your question, my copy doesn't, but I trust Mr.
Mr. Hughes, will you stand up and let the clerk know what defense numbers are the two reports that have been previously marked?
So the first report is an October 13, 2016 preliminary report, and it is defense exhibit number 3044.
For ID, it's not in. It's just ID.
Just that for identification purposes. For identification purposes, Sally Smith's December 5th, 2016 report is defense exhibits number 3045, and that's pages 1 through 46, and it's currently being printed.
Or can't we just put the first page
that's
up
fine.
if you want?
That's fine. Okay. I apologize for that.
No worries. Thank you, Mr. Hughes.
And to the clerk for attempting to gum up the works one more time. Does your December 2nd, 2016 report, Defense Exhibit 3045, does it also reflect your opinions and conclusions as of that date regarding your investigation?
Regarding my medical evaluation, yes.
Okay. And just if you would briefly tell the court what your opinions were regarding this matter as reflected in that report.
As reflected in that report, it was my conclusion that there was what we call positive findings for medical child abuse, and that the medical record review and the history taking and that kind of thing that I had reviewed provided very strong evidence to support that conclusion.
Okay. Was there any conclusion, and is that the conclusion of medical child abuse would colloquially be known as Munchausen by proxy?
Yes, and I believe it's even in what we call the impression. That was my conclusion in the report. I put in parentheses Munchausen syndrome by proxy because that's kind of a well-known term for this situation.
Okay. And did you reach any conclusion regarding conversion disorder?
Yes.
And what was that?
It was my opinion based on all of the observations of the various medical staff and team and staff members, etc., as well as based on multiple other physicians' reports that I had reviewed, that she had a conversion disorder. It's actually called a functional neurological disorder now, but at that time it was called a conversion disorder.
When you say she, you refer to Maya Kowalski?
Maya Kowalski, yes.
Okay. In reaching the conclusions and opinions you just expressed to us, how many pages of medical records did you review?
I don't know exactly as I sit here, but well over 2,000.
Okay. And I see you brought with you today a stack of 3, 4, and 5-inch binders that is on the table in front of you. Are those at least some of the records you reviewed?
Those are all of the medical records that I printed. So there are some that I reviewed in the electronic medical record from Johns Hopkins All Children's Hospital that I don't have copies of. But everything that I had a copy of in terms of all her medical records going back to actually her first visit to the pediatrician up in Chicago is in those binders.
Okay. And did the material you reviewed also include certain online WordPress blogs that had been created by Beata Kowalski?
Yes.
I believe that's all I have, Your Honor.
Mr. Anderson, do you have anything in profer?
Dr. Smith, before, or let's say, right at the start of this, in the first part of October, you had a call with Dr. Kirkpatrick, did you not?
I did.
And Dr. Kirkpatrick explained to you that he had been treating Maya Kowalski for CRPS, correct?
He did.
And he told you that statistically speaking, CRPS is often mistaken for conversion or Munchausen by proxy, did he not?
I don't really remember exactly what his words were. I took a few notes from the conversation that I had with him, and I know that there was some general discussion along those lines.
And yet you did not put anything in your report about Dr. Kirkpatrick, did you?
Yes, I believe there's a whole section about his medical records.
Yeah, except for the fact that you did not tell anyone in that report that he had warned you off of going after the Kowalskis.
It's completely irrelevant for a child protection team medical evaluation, because that's the whole point of the evaluation and gathering all the records. The problem in these cases is that the treating physicians have not done that. And so the fact that he, who sent her to Mexico for the ketamine coma, told me not to investigate child abuse, it was completely irrelevant to me, because my job was to investigate child abuse. So if I had come away from my job saying, I was supposed to do this, but this doctor told me not to, so I'm not doing it, and there's no evidence of anything here, I would not have been doing my job even remotely near a standard of care.
Do you not understand the importance of putting both sides of the story in your report?
The both sides of the story is the responsibility of the various people who are going to present it to the court. My job as the medical director for the child protection team is to do what I need to do to assist the investigators and the detectives and the attorneys that are involved in the case as to whether there is evidence to support a diagnosis of whatever type of child abuse is being assessed. So it's not my responsibility to lay out some whole long argument about what it might be otherwise if I have extensive evidence to support that it's a type of child abuse.
Dr. Smith, you know there wasn't a single child psychologist or child psychiatrist that diagnosed what you were claiming. You're aware of that, right?
That's also irrelevant.
So you are the ultimate decider of medical issues which you have minimal or no training in.
I have extensive training.
Yes, but
it's a profer. You can answer, Dr. Smith.
I have extensive training in evaluating child abuse and neglect. Medical child abuse is a child abuse pediatric diagnosis. There is a parallel track in psychiatry where there's a thing called factitious disorder imposed on another, which is assessing the perpetrator or the caretaker in that scenario. But I don't need a psychiatric degree to assess medical child abuse. I'm very well trained to evaluate medical child abuse based on my child abuse pediatrics experience and board certification.
Well, there's not a single child psychologist or psychiatrist that agreed with you. You do realize that, don't you?
No, I don't.
Well, name a child psychologist or psychiatrist that examined Maya Kowalski who agrees with you.
Well, that wasn't their job to write in the report whether there's medical child abuse, so that specific thing documented by, for example, Dr. Cabot or Dr. Katzenstein, I don't know, honestly. I'd have to look back to see if they ever documented that as one of their diagnoses, but that's not their job. My job is to assess that, and if I present adequate evidence to the court can act on that. So, you know, the court has every ability to pull all these people in, including Dr. Kirkpatrick, including Dr. Hanna. I think they testified in the dependency action. And if the judge decides that there's serious question about whether I'm right, then, you know, the court makes that decision based on the evidence that they receive. That's not my job to litigate the whole thing and put out all of the potential possibilities in the case and say, I'm the child abuse pediatrician, but I don't really know if there was child abuse here, because in this case, there clearly, in my opinion, was child abuse here.
Yeah. So you did not put in any of the conclusions or any of the data from Eagle's Wings and those therapists and psychologists that saw the Kowalskis, did you?
There was a licensed clinical social work intern who saw Maya and her family at Eagle's Wings, and I don't honestly know where that was in the pile of records when I was writing up my report. I kept writing part of the report, having to do other things, writing part of the report, having to do other things, and I inadvertently did not include that in my report.
Well, you did research it enough to realize that Rebecca Johnson had a master's degree and over 20 years of experience as a therapist at Eagle's Wings. Did you not?
Well, the question really, in terms of my part, is whether...
I'm just asking if you knew that or not, ma'am.
I knew I'd have to look and see exactly what her credentials were. I'd certainly, defer to you if you're reading her credentials off. But it's irrelevant unless she did the whole thing I did, looking at all these medical records, and has expertise in medical child abuse, for her to be able to say one way or the other if there was child abuse or not.
Okay, look, did anybody agree with your assessment that there was no CRPS?
Yes, I believe they did.
Who?
I believe that there were multiple people on the hospitalist team that didn't think she had it, and I believe that although there was probably some question about whether she might have some sort of amplified pain disorder, the pain management team didn't think she had CRPS.
Well, amazingly enough, we did have Dr. Elliott in here to testify, and he never said that she did not have it. None of the doctors so far testified, A, that they were experts in CRPS, or B, that she did not have it. Are you aware of that?
No, I'm not. I wasn't supposed to watch any of the testimonies. So I have no idea what people talk about.
Gather that. From your investigation, though, at the time, did it come to your attention? Nowhere in any of the records did anyone who had any expertise in this, that is a pain management doctor, a neurologist, or an anesthesiologist, ever agree with your assessment that there was no CRPS?
I think I just answered that. Yes, I believe there were people that had the same opinion.
Okay. What Did you check with Dr. Spiegel, a board-certified neurologist that treated Maya and confirmed CRPS?
Objection. Assumes facts, not in evidence.
Go ahead and answer.
Dr. Spiegel had this 10-year-old child do hyperbaric oxygen treatment, I believe, on 40 occasions in a row, when she also got ketamine on some of the same days. So I wasn't terribly worried about whether he thought or did not think that she had CRPS.
Because you'd already decided in your mind that a board-certified pediatrician with his years of experience was not qualified to render an opinion on that. Is that right?
Objection misrepresents the credentials, and I ask for comment on another crime bill. No witness.
Go ahead and answer.
I'm sorry.
Dr. Barr,
yeah,
a board-certified neurologist, he testified and confirmed CRPS. Did you put that in your report?
I don't know that I specifically said that he said that diagnosis. I think, as I recall, without going into the stack, that I did say in the history that Dr. Kirkpatrick had diagnosed her with that. Those people might have had that opinion. I don't think, based on my review of the CRPS literature and discussions with physicians since then, and in the context of all the evidence that there was of medical child abuse, that Dr. Barr's opinion, if that was his, that she had CRPS, was reliable.
Okay, so now Dr. Spiegel is not reliable, and he's a neurologist. At least will you agree that neurology and anesthesiology are the two areas that are most involved in the investigation of complex regional pain syndrome?
I imagine those are people that typically evaluate and treat patients with complex regional pain syndrome, sure. But not all neurologists and pain management or not all neurologists or anesthesiologists are, if you will, created equally. There are some who practice at a very high level, and when having reviewed medical records from all kinds of providers all over the state and even other parts of the country for 35 years, read through information and see all the supporting information that they have and compare that with other information that I gather in my medical record review, I can assess whether the person that made thousands of dollars was reliable or not. And I didn't find those people to be particularly reliable in terms of their diagnosis, even though I certainly included their information in my report.
Dr. Hanna, an anesthesiologist with over 25 years of experience in treating CRPS, you didn't put his confirmation, he did a diagnosis of CRPS in your report either, did you?
I believe in the history I made reference to that. I'm pretty sure I did say that he, made that diagnosis. But this is a doctor who was giving a 10-year-old child who was on the small side, 1,000 milligrams of ketamine, anywhere between 8 and 32 milligrams of Versed, doses of Zofran, 1,750 milligrams typically of magnesium, all at the same time in an outpatient setting with no documentation of vital signs, and there was indication in the records that appeared to me to suggest that the family member was the person monitoring the pulse oximeter. So that person, to me, is not particularly reliable in terms of whether this child needed the treatment that she was getting, whether he had made an accurate diagnosis or not. So I put his information in my report. Yes, I discounted his diagnosis.
And of course, you discounted Dr. Cantu's confirmation of CRPS.
Well, I never got any records from Dr. Cantu, so I couldn't really address that whole situation other than from the WordPress blog. This person put a 9-year-old child in a ketamine coma for days. It took her probably about a week to just be able to be discharged from the hospital after that.
So
I didn't find him reliable from what I saw.
All right, so if I'm understanding you, the fact that 3 different treating anesthesiologists specializing in CRPS, 2 different neurologists specializing in the treating of CRPS, you know more. Fair?
I don't know more. As I said, I looked at their information, and based on what was done with this particular child, I did not find their opinion to be reliable.
And who elected you to be the judge of whether all of these board-certified physicians were reliable?
Nobody. I presented it to a real judge who made a determination.
Well, isn't it true, ma'am, that you are not a medical investigator? You are, in fact, a medical prosecutor.
That's absolute nonsense.
Because an investigator would include both sides of the story and let the judge decide, right?
No. The Child Protection Team medical director will assess whether there's medical evidence to support a diagnosis of child abuse, and then the dependency attorney will present that to the judge. And the other side gets attorneys also. There were 5 in this case. And they present all the information, and then the judge tries to decide, you know, whose information is more reliable.
Here, under oath, are you telling us, are you an investigator or are you a prosecutor?
I am neither.
The information.
I'm a medical doctor who is an expert in child abuse pediatrics.
Mr. Anderson, I'm giving you very wide latitude.
I'm done.
You're finished?
Yep.
Okay. Mr. Hunter, anything further in profer?
Very briefly, Rob. When you spoke with Dr. Kirkpatrick and he warned you off, did he tell you that he had last seen this child 10 months before the conversation?
I honestly don't recall if I already knew that. I might have already known that.
And when you wrote your report, you had the Tampa General Hospital records, the Lurie Children's Hospital records, the All Children's records predating October of 2016, correct?
Correct.
And all those hospitalizations with all those specialists that saw this child, you see any of them suggest that CRPS was the diagnosis?
No, and multiple were experts in complex regional pain syndrome.
Thank you.
Is the profer complete?
Yes, sir.
Yes.
Okay, Madam Court Reporter, note that the profer is now closed. Dr. Sally Smith, you had looked at a little report during your testimony. Can you hand that to me? I'm going to hand it to the
You can keep it if you want.
Okay. I'm going to hand it to the clerk. Let's mark it as whatever the next number for plaintiff for ID purposes. And just tell us what that number is.
2804.
So the report that Dr. Smith looked at during her testimony in front of the jury is ID'd as 2804. It's not in evidence.
I'm sorry, I think you said in front of the jury. I think you meant not.
No, earlier during her testimony, she had pulled out a report, and that's what we just identified. Now, does
Jury's not
Dr.
getting
Sally
good at
Smith, is she released or does she need to remain under subpoena?
She's released by plaintiff.
Released, Your Honor. You can watch them.
If you are released, you are no longer subject to the rule of sequestration.
Okay.
Thank you.
Thank you.
Okay, let's be back here, everybody, at 1:30. I will try to review Mr. Anderson's edits to the jury instruction. If you could let Mr. Altenburn and Mr. Elegant know that I'm going to try to address it at 1:30. Well,
Mr. Altenburn.
I'm just letting you know what my plan is.
Thank you, Rob.
See you at 1:30.
Oh my goodness. I'm struggling with this one. Love Disney Magic. I can go into this here another time here. I'm struggling with staying neutral and open-minded after listening to that. I'm reflecting back at last year. I was asked to run video and live stream a graduation. What do they call it? I forget the name of the ceremony where medical students receive their. Basically, they're released onto the world to go practice. Okay, I know there's a term, and it's a big long term, and I can't remember it off the top of my head. But I was struck at the time as they all stood and took the Hippocratic Oath, and I listened to that. I'm looking through. I realize there's some different versions out there. I believe. I will not be ashamed to say I know not, nor will I fail to call in my colleagues when skills of another are needed for a patient's recovery. I will respect the privacy of my patients, for the problems are not disclosed to me that the world may know, but especially must I tread with care in matters of life and death. It is given to me to save a life, all thanks, but it may also be with my power to take a life. This awesome responsibility must be faced with great humbleness and awareness of my own frailty. Above all, I must not play at God. I will remember that I do not treat a fever chart, a cancerous growth, but a sick human being whose illness may affect the person's family and economic stability. My responsibility includes these related problems if I am to care adequately for the sick. I will prevent disease whenever I can, for prevention is preferable to cure. Oh my goodness. I struggle with what I saw on the stand from this witness and matching up this oath that the doctors operate under. The do no harm. It seemed to me that there was very much a confirmation bias that her job, even when she says, my job is to find the evidence of it, and the other side, the other guys, if they want, they can defend themselves and try to defend themselves in court. My job is to find it. My job is to look for everything that's bad. And if I find anything good, there's no disclosure rule. There's no law in place where she's like, I found this. This actually helps the family. I have to put that in my report as well. No, that is discounted every single time. Her report was a hit piece. That's how I feel. Her report was a hit piece. Was there strange treatment going on? Yes. Was it outside of the norm? Yes. Was it done by professionals in that area? Also, yes. I'm gonna need my tree picture. We're gonna focus on a Zen moment for just a minute while I do some deep breathing. This was offensive for me to watch. Honestly, I'm looking at this and thinking, and this woman still has access, still has rights, still. Oh my goodness, it's okay. You guys, we need to take a lunch break. I think we have an hour. I'm going to lay down and do some deep breathing exercises and maybe yell into a pillow. But that was the spiciness we did not see during the original cross by Anderson. It seemed very tame. It all came out in this proffer. And everyone's saying, why is the jury? Will the jury hear this? They won't. This proffer is for appellate reasons. When this goes to appeal, the appellate judges will consider this information, which the judge has ruled is not going to come in to this trial. And that's where it's going to go, and it will be appealed. Both sides have said we're appealing. Okay, we're appealing this, and it's gonna come in. That was frustrating to watch. To think that Sally Smith wears a badge and carries a title that says child protection on it, but it seemed nowhere in her testimony did I hear that her goal was to protect the child. Her goal was to find fault and find error and get to the child out of the family's care. That's how I feel. That's personal opinion, but that's it. Mom and Maya were punished for trusting doctors. That comes up again and again. If there was medical child abuse, why was it not pursued? Why was that not pursued legally against the doctors who were prescribing the treatment, who were doing the treatment? It's just it doesn't add up to me. All right. Thank you everyone for being here. This has been a lot of fun. We only have, by fun I mean I don't want to repeat that again. I don't think my blood pressure can handle another one of these testimonies today. Wow. Did Maya continue to receive ketamine treatments after her mom died? No, Writer Dust, she did not. Those stopped at the court order, and she still, to this day, has not been able to receive ketamine treatments, even though she has expressed a desire to do so, I believe. When she turns 18, she will no longer be bound by that court order, and if she chooses to, she can receive ketamine treatments. But to date, she has not had any more. And I'll admit that goes to the defense argument. It really does about the diagnosis of especially about the treatment for her condition, about therapy and about the physical therapy and how you use it, and eventually the movement goes away. Apparently, to some degree, that has worked to get Maya to a healthy state right now, as the CRPS has been in remission a bit. I know we've got people who have had very different experiences with that say no, therapy does not help. It's excruciating and it makes it worse. But I don't know. I'm struggling with that. I want to thank our incredible mods. You guys, I wish you could see the work they do on the back end. We have some amazing mods that are working their tails off, both answering questions and helping moderate in chat a little bit. When there's 6,000 people here, it gets a little crazy, and you can see as chat scrolls pretty fast that's the case. Thank you, and thank you to all of you to be here. We're not done. We've got another half day of this that's going to continue, and we're going to pick up after lunch. Can somebody tell me the time that we're coming back? Was it 1:30? I was still doing my breathing exercises, and I didn't listen to the judge when he said that. Snazzy Trinket says, very frustrating. There are 2 or 3 cases involved that cannot be discussed in front of the jurors. DCF, appeals, past settlements in this case. It's a lot. It is a lot. The judge. I think the judge has done the right thing in making this case stand on its own. Let's see. 13:30. So 1:30. We're going to come back at 1:15. Then that gives us a little over half an hour to have a little break. We're going to stop this live feed, grab a drink, get a break, stretch your legs, step outside, breathe some fresh air, and we're going to come back and finish out the day. The jury did not hear that proffer. They have no idea, but they did see the depositions, and I would say that what we saw today was much closer to what we saw during the depositions. So they have an idea there. Everybody breathe. Everybody breathe. We're gonna play some music, and I'm gonna probably crack open my Mountain Dew earlier than I should, so I'm gonna fall asleep this afternoon. Oh man, can't get the burner number to come up. I'm sorry, when chat gets this busy, the tool that puts up the burner information gets overloaded. I've talked with the maker of the tool and tried to get this resolved, but it just doesn't work. Let me see if I can trigger it here. If somebody can manually put it in chat. There it is. There's the burner phone. I'm not taking phone calls in right now unless it's Jules, but if you send me a text message, I'll be able to look at that and respond, or make an attempt at responding. We've had a lot of different people reach out to me. We've got several things going on. We've got BK in court today. I've got to turn the music down here. We've got BK in court today, I believe, trying to get the whole thing thrown out, right? And he's done this a couple times with his lawyers. I don't think that's going to happen. I'm not covering that live. We've got the manhunt that's going on up in Maine that is still going on. We covered that live last night as far as during the active shooter portion was going on. We have, let's see, what other trials are going on? I've got this one in Colorado that's just about to start up again. I need to start the recording on that one. That'll be on my other channel, on the Top Mark Media channel, and that is the Woodyard trial, the police officer who was charged in the death of Elijah McClain. So we've got that's going to be posted. We just posted 2 more parts of that trial last night because the judge has given us permission to post it, but we can't post it live, so we have to post it at the end of the day. So those are up. Yes, we've got a lot. We've got a lot going on, and I've completely run out of music, so I'm going to have to cue the music again. Let's see. Emily D. Baker is covering BK. Wonderful. She's got some great insights. Love her. Great hair as well. What's with LawTube and great hair? You've got Ian. You've got Lawyer You Know. You've got Emily D. Baker. There's Rob. Sorry. I'm going to be right there, right behind you. If you look at me from behind, there's a little solar panel appearing through my hair. All right. Thank you guys. Have a great lunch. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe to go live again, which will be in 30 minutes from right now. 30 minutes from right now. If you want to be first in chat, what I recommend is click the subscribe button. Click the subscribe button. Ring the bell, and then just refresh your screen over and over, because within the next couple of minutes, we'll go ahead and put that up live, and the first person in chat wins the internet for the day. I mean, where else can that happen? Only here do we give away the internet. Something we have no legal claim to. Set Siri to wake me up in 25 minutes. I cannot sleep right now. I would not be able to. Tamara, thank you very much to the moderators. Thank you so much. They are fantastic. We're gonna take a break. I'm gonna get some food. We'll be back here for the second part of the Maya trial, which might be spicy. It might be slow. We might have some depots. I'm not sure for sure what's coming up next. But we are nearing the end of the trial. We expect the defense to rest by Tuesday night, maybe Wednesday morning. So the end is in sight. Thank you very much. You guys, appreciate you all being here. Thank you so much for being the best community on the internet to watch true crime with. That's because of you. Wouldn't be the same without you. Have a good lunch. We'll see you after. Bye.
Is that correct?
Scratch all that. Oh, that was terrible. I apologize.